All right, we are live.
Good morning. Welcome to the May 13th, 2020 sitting of the Massachusetts Appeals Court. Let me introduce the panel for today. Sitting before you is Justice John Englander, Justice Catherine Hand, and I am Justice Eric Neyman. We will be your panel for all 6 cases today. I will remind counsel that normal appellate court rules are in effect, so each side has 15 minutes to present your argument. We have read the briefs, we are familiar with the record and the facts of the case, and we have also researched the case law, so I would urge you to cut to the chase and go straight to your best argument, although your 15 minutes are yours to use as you see fit. I would also remind you that there is no rebuttal in the appeals court. Also, this case and all of our cases today are being live streamed. And so this is live and will be recorded. So counsel, please act accordingly. And we will call the first case on the list. This is case number 2019 P1135, Commonwealth versus Smith. We will hear first for counsel for the appellant, Attorney Hahn.
Yes, good morning, Your Honors. Alex Hahn on behalf of defendant Brian Smith. The Commonwealth has conceded in this case that the defendant was mentally ill at the time of the offense. And as a result, the legal question becomes whether or not the Commonwealth shouldered its burden on the second 2 prongs of a criminal responsibility defense. Specifically, did the defendant understand the wrongfulness of his actions? And did he have the ability to conform his actions to the law? The Commonwealth bears the burden on both of these matters. That burden never shifts, and it is burden beyond a reasonable doubt. Also relevant generally, the SJC has found that the Commonwealth, if it doesn't have an expert witness on the question of criminal responsibility, proceeds at its peril if the evidence of criminal responsibility is otherwise relatively weak. And the Commonwealth did not have an expert witness in this case.
Excuse me, now,
Yes,
your client did have an expert witness in this case, correct?
That's correct, Your Honor.
And your expert concluded that your client was mentally ill at the time of the incident, correct?
Correct, Your Honor.
However, your expert could not draw the conclusion that your client was not criminally responsible. Is that also correct?
Yes, she could not reach an ultimate conclusion on the 2 prongs, the did you appreciate wrongfulness and could you conform to the law. I would view her testimony as somewhat in equipoise on that question, and I don't think there's enough from her testimony to remotely support the Commonwealth beyond a reasonable doubt. And in fact, I think primarily the balance of her comments on the stand and her report are supportive of the defendant, which I will address.
Does the Commonwealth have to have expert testimony?
They are not mandated, no. The case law is clear on that, but it does say in Commonwealth versus Lawson that there's certainly a risk to proceed without expert testimony because these...
I'm sorry, go ahead.
Well, just that this kind of issue is so susceptible to expert testimony. I mean, these are very complex issues of mental health involving changes to the brain, things like that. So expert testimony, I think, would be extremely important, which is why the SJC has broached that concern, Your Honor. And I'm sorry if I cut you off.
Oh,
no, you didn't cut me off. I'm actually very interested in exactly this question. Do you agree that we're just applying a Lattimore standard here? And so the Commonwealth, by conceding mental illness, takes on 2 additional elements to this case. 1, that they proved that he was able to conform his conduct to the law. 2, that he was able to appreciate the difference between right and wrong. But we're just applying Lattimore, right?
That's right, Your Honor. There was a motion for required findings. So this boils down to Lattimore. The Commonwealth shoulders the burden. They're sort of proving a negative, in fact, but, absolutely right. And the standard is ultimately going to be reviewing.
I don't know why you say that they're proving a negative. I think that they have just 2 additional elements. They need to show that the defendant could appreciate right from wrong and had the ability to conform his conduct to the law.
Yeah, I think that's sure. The SJC in one case did refer to it as proving negatives, but I think that's the way you've characterized it, and as does my sister in her brief, is a simpler construction of simply that they have the burden of proving those matters. I would completely agree, Your Honor.
So if we're applying Lattimore, then we look at the evidence that the prosecution put on, right?
That's correct.
And help me, was Lucier was a defense witness?
She was the expert for the defense, yes, Your Honor.
Okay, so they don't need an expert, and the evidence that they put on includes these two pieces of evidence that the prosecution seizes on. One, that the batteries were removed from a phone, and the second, that he immediately stopped when she offered him money. What do you say to that? Is that enough? And if not, why not?
Sure, Your Honor. Those are two facts the Commonwealth emphasizes, and I believe there's a third involving another phone. They lay out, pretty methodically the facts they're relying upon. I think that in the aggregate, the evidence as put forth by Lucier and also the circumstances of the crime are going to be more supportive of defendant. Those particular facts are some degree probative of the elements the Commonwealth is trying to prove. But I think even there, we have to look at the context of the overall offense, sort of what happens here. And I think the beginning and the end, and I will address those three factual points, Your Honor, but I think the beginning and the end are sort of the context of this attack. This is a horrible attack, and I think at the end of the day, the word rational is what that's going to boil down to what the court needs to look at. Did the Commonwealth prove beyond a reasonable doubt that the defendant was thinking rationally? The SJC in the DEIDRE case, in which it developed a model jury instruction on this matter, views the conformity to the law prong as involving, quote, a substantial ability to exercise a free and rational will to choose to obey the law. So I think that free and rational is at the heart of this. So when Mr. Smith was engaging in this panoply of actions, including the one cited by the Commonwealth, was he acting freely and rationally in terms of obeying the law? Now, the issue of there's two phones that are discussed, sorry. First, he throws her cell phone across the room. This becomes sort of an earlier point in the attack. And I did not see in reading this, even in a light favorable to the Commonwealth, involving any sort of rational thought or ability to attempt to avoid capture or something like that. It appears motivated entirely by rage over Ms. Doe allegedly stealing his music, which is not accurate at all. But I think that particular fact is not particularly probative of him acting rationally. The second phone is her.
Under the Lattimore standard, I'm sorry to interrupt, but under the Lattimore standard, isn't that an issue for the finder of fact to resolve?
Sure, it is a factual issue, but this court is reviewing the matter under Lattimore to decide, did the Commonwealth prove all of those elements? I mean, Lattimore is very clear that the Commonwealth bears that burden, and sort of as a matter of due process, this court probes that matter. And the standard is in a light favorable to the Commonwealth and asks, could a rational fact finder have reached this conclusion? And I feel strongly in this matter that the fact finder, with great respect to Judge Parator, did not reach a rational conclusion, Your Honor, but absolutely that is the standard.
Well, why viewed in the light most favorable to the Commonwealth, could the judge not have concluded that the purpose of throwing the phone was to prevent the victim from reporting an ongoing crime? Why is that not a possible rational inference to draw from that action?
So of the facts the Commonwealth cites, I would agree that is probative. And just to be clear, I believe the standard is this court reviewing in the light most favorable to the Commonwealth. Of course, at trial, the Commonwealth bore that burden. But the question ultimately is for this court is, was the fact finder rational, and does this evidence viewed in a light favorable to the Commonwealth support the verdict? And that's a matter of due process. But take your point, Your Honor, that of these facts, that one is probably most probative. I would just say that the aggregate of the evidence, some of which I can further get into, does not get the Commonwealth over that hump to beyond a reasonable doubt here. Again, this court is examining whether that question of rationality was proved. So I don't think so I think the second phone matter of taking out the batteries is probative. The money, I think, is an interesting one. So that's what causes this attack to end. But I also want to just sort of get the bookends of this attack, how it begins and ends both extremely abruptly. It begins when they're, in essence, having a tender moment. Mr. Smith is at Ms. Doe's knees, and she testifies that he is essentially being sweet, is her words. Suddenly, almost out of nowhere, a roll of her eyes causes him to begin this attack. Not moments, but several minutes later, after a brutal attack, she offers him money, sort of gets this thought of offering him money. And her testimony is this: he all of a sudden changes, like snap your fingers. That's page 26 of volume 1. So the attack begins and ends. I don't think impulsivity begins to capture it. I think it's more rapidly shifting states that's really consistent with the diagnosis that Dr. Lucier gives us. So I don't think it's particularly.
First time, actually, it wasn't just a roll of the eyes. It was her talking to him about infidelity. And the second, the ending, apparently he had money issues, right? He wanted her to buy cigarettes earlier in the evening. So we aren't, I'll concede, we aren't given a full picture of either of those potential motivations, but am I wrong to think that the record would support a little bit more than an eye roll or the only time that money had come up?
So I think it's the eye roll that's the catalyst. I mean, they do begin to enter a dialogue about his infidelity. It does not appear to it doesn't appear that it would turn violent. That's what's strange about this and remarkable. And I think we look at this too, Your Honor, in the context of the history of these individuals. Ms. Doe on the stand draws a really fulsome portrait of their relationship. 3.5 years. She is obviously a formidable person, a kind person. I mean, it really radiates from the page, and that their relationship was a substantive one. She describes him at this trial, says at one point she viewed him as a loving person, a kind person. So the sheer irrationality of this, there's no planning for this attack. And one of the cases cited by the Commonwealth, I believe it's Griffin, is an interesting one because it did involve a fairly delusive individual, but it also involved planning. And in this case also, I think after the attack ends, he leaves. It just seems to be almost in a casual manner. I mean, he has no understanding that he's in legal jeopardy. He seems to have no understanding he's done anything wrong. I mean, this is someone who clearly, Ms. Doe trusted this man, despite all of his myriad flaws, trusted him, and yet he attacks her in this manner. So I don't think it's really, I think the total picture is one of irrationality, I'm sorry. And I think also, so I'm not trying to say that those facts aren't probative, and particularly the phone one, and to some degree the money aspect are probative of that issue of rationality and ability to conform. I'm just questioning whether—
in your brief, you say that he never took the money, but the way I read the record, he did.
And I apologize, I did want to bring that to the court's attention. So I think I read the direct testimony as indicating that he didn't leave with the money. Upon preparing for this, I did again read Judge Parator's colloquy, and he does elicit testimony that she actually left with the money. So I don't want to remotely mischaracterize the record. So I did want to bring that to the court's attention. I still think it's not the receipt of money that motivates him here, and I don't think $60 or $80, notwithstanding money problems, is going to be it doesn't have the ring of rationality that he's going to stop an attack, or that this attack was somehow based on money. Again, I see it as he sort of snaps in and out of the attack. I'm about out of time. I did just want to emphasize that Dr. Lucier diagnoses him as being manic, having mania with psychotic features. Psychosis is a very significant ailment.
Is there anything in the record, because I could not find it, about Lucier's background? It appears that she's frequently a state employee, in the sense that she offers opinions that the state retains her for with respect to criminal responsibility and the ability to stand trial. But is that in the record?
I don't recall, Your Honor, as specifically her. I know it indicates that she's testified in perhaps hundreds of cases. So clearly experienced in these matters. I don't recall, as I sit here, whether or not she was primarily a Commonwealth witness or not, but I think she's a thoughtful clinician who doesn't get ahead of herself in terms of this, but her overall diagnosis is a serious one. She indicates he has a substantial disorder which interferes with his ability to recognize reality. Recognize reality being, I think, the key phrase, and I apologize for going over, Your Honors.
Let me just check with the panel. Justice Hand, any further questions?
No.
Justice Englander?
No.
Thank you, Attorney Hahn. We'll now hear from the Commonwealth.
Thank you, Your Honors. Good morning, and may it please the court. Lindsay Russell, Assistant District Attorney for Middlesex, on behalf of the Commonwealth. I ask this court today to affirm the judgment of the Cambridge District Court, in which, during a jury waived trial, the court found that the defendant was in fact guilty of these. As Your Honors and my brothers pointed out, essentially we did concede the fact that the defendant did suffer.
I'm going to stop you. Attorney Russell, I'm sorry, I'm going to stop you. You're fading in and out, so it might help, number one, if you speak a little bit more slowly.
Sure.
Number two, you're moving back and forth in front of, I think, the microphone, so it may help if you stay in one spot. Possibly.
Okay. I'm sorry. Can you hear me better now?
Yes.
Okay. Justice Englander, did you have a question or?
Not yet, but I do have questions.
Okay, I apologize. Now here, the Commonwealth did essentially concede mental illness, and that meant that the Commonwealth had to show both that the defendant had the substantial capacity to appreciate the wrongfulness of his actions, as well as to conform his conduct to the requirements of the law. Now, the Commonwealth need not present its own expert on these issues, and we can look to the facts of the circumstances of the crime here. And I think what my brother says, in that this boils down essentially to rationality, I think that's definitely correct. And here, not only do we have during the attack, which I'll get to, but we also have before the attack. Now, there was uncharged conduct here involving an incident in the kitchen the day before, in which the defendant was pulling the victim's hair. When she asked him to stop and said that it was hurting her, he did in fact stop. Later the next day, at the time of this crime, the defendant and the victim had gone to New Hampshire to retrieve the defendant's vehicle. The victim said that it was more or less a pleasant day, and the defendant was able to follow her back in his vehicle to Massachusetts. Later, he clearly did not want to go to the hospital to do this mental health intake that the victim thought would be helpful. He snuck out of the hospital. I see that as rational behavior and doing something he didn't want to do. He said he was going to the bathroom and instead left. Later on that same night, he essentially tricked the victim into buying cigarettes for him without upholding his end of the deal, which was that he was going to let her drive home, and instead she had to walk all the way home. And again, once they got home—
see it as rational behavior, counsel. When you say you see this as rational behavior, the testimony is unequivocal that he was suffering from mental illness at the time. There's also testimony that I don't think can possibly be controverted, that he was having a paranoid episode at the time that the crime occurred.
Your Honor, I'm not sure we can actually say, we definitely did not concede that he was having a paranoid episode at the time. What was conceded is that this defendant did have bipolar.
Counsel, what evidence is there in the record that he was not having a paranoid episode at the time? He is talking to her throughout the entire time that he is doing this about her and someone that he hasn't seen for 3.5 years conspiring to take away her music.
Right. Your Honor, I think the two things that instigated this fight were the jealousy issues of infidelity, which I would suggest is a rational impetus for many domestic violence crimes, as well as what Your Honor mentions, the stealing of music from the iPad, which to me sounded more like a misunderstanding of technology. But I do understand that those were both motivators here.
Maybe it would be a misunderstanding of technology if he didn't mention the fact that she'd conspired with someone that she hadn't seen in 3.5 years. The burden is on the Commonwealth. What evidence is there in the record that he was not suffering from a paranoid delusion at the time that he was conducting the attack?
Well, I would just reiterate here that, again, what we needed to show, even if the defendant were suffering from some sort of paranoid delusions, that he can still be criminally responsible if he's able to appreciate the wrongfulness of his conduct and conform his conduct with the law. And even the defense expert said, even in her own testimony, she said that not everyone in the throes of a mental illness episode is going to lack criminal responsibility, and the case law suggests the same.
Right, but she also said, when asked specifically about paranoia, that that's an indication that they could not appreciate right from wrong.
Right, but the other indications that we do have here that the defendant was rational and to the actions that actually occurred during the attack. Not only did the defendant take the victim's phone at the beginning of the attack and throw it across the room, but I think something that wasn't mentioned in my brother's argument was that he also took the phone with him afterward. He had it in his pocket. She saw it there in his pocket when he was leaving. She was going to attempt to take it from him and then decided that that was probably not a good idea and instead let him leave with it. He had also taken, she happened to have a landline phone too.
Counsel, let me just make sure I understand that point. So what you would like there is an inference that he took the phone in order to prevent her from calling someone about what had just occurred?
From calling for help, Your Honor. This was a brutal attack, and she was pretty hurt afterwards. She had a broken pelvis, a broken nose, and because the defendant had essentially taken both of her phones, she had to go to a neighbor's house to even get help. The defendant lived there, and he was not arrested that night. You'll see from the docket he was arrested until the next day. That all shows evasion. And those are actions that definitely occurred after the crime. But again, during the incident as well, I know we brought up the issue of the victim realizing she had money and offering that to him. I will suggest that while it's an interesting situation there where he did suddenly stop, even the defense expert here said she conceded that were we to believe the victim, which it sounds like Judge Paratori here as the fact finder did find her credible, that happened, that in fact would be evidence, potential. I think her words were exactly that would be potentially evidence of an ability to conform the conduct. I also want to mention that if defendant—
Can I interrupt you here for a second? How would that be evidence of ability to conform to the law? I appreciate what Dr. Lucier's position was, but how does that speak to that prong?
So it means he had the ability essentially to stop once given the proper motivation. And that motivation here, I would suggest, was not an irrational one. The motivation was he thought somebody had taken something from him. And as Justice Englander mentioned earlier, the defendant clearly didn't have a lot of money. And he offering money would monetarily compensate him for what he felt was stolen. And essentially—
Could I interrupt you? That may be the case that there's a basis for a cause and effect for why the conduct stopped on the receipt of the money. And I'll assume for the purposes of that point that there was evidence that he was short on funds in some way. But again, how does that go to the ability to conform to the requirements of the law, not conform to some rational purpose, but that particular prong?
Well, I think what that prong really means and is that if somebody is able to essentially when he's stopping the attack is when he's conforming to the law, because he should not be attacking her. The law says that he shouldn't, and he does stop his behavior. It shows that once given the proper motivation, he can, it's not as if he's in some fit of rage where he's never going to stop until somebody else comes in and physically takes him off of her. There was something here that stopped him, and that was money. I would just also note that
that indicates that money was at all a motivation for the attack. Money isn't mentioned at all.
I would again suggest the fact that part of the motivation for the attack, according to the victim, was the stealing of music. And so I would suggest that to be monetarily compensated would be an ends to that means. I would also suggest that, as your honors pointed out, that all reasonable inferences should be drawn in favor of the Commonwealth here, given that we are looking at this through a Lattimore standard. And for that reason, in the totality of everything, I think that really is just one factor here that goes toward those prongs. I would also like to mention that after the attack, the defendant was, when he interviewed with Dr. Lucier, which was not until months later, but he minimized his involvement in the attack. He said that he gently placed his hand over her mouth and that she acted like I hit her. That all shows minimization, and I would just point the courts and an ability to mislead. And that shows an appreciation for wrongfulness of conduct, because it's rational to not want to get caught and to cover up your role. And clearly she had horrible injuries after this. This wasn't something that would have come as a result of him merely placing his hand over her mouth.
Counsel, I'm sorry to interrupt, but let me go back to your earlier statement. I think you just said that the fact that the defendant stopped the criminal activity was an indication that he could act in conformity with the law. Is that actually what the evidence shows, or is it the fact that he responded to an incentive, that he responded to the promise by the victim or the request of the victim? Is that what tends to show that he can act in conformity with the law?
Yes,
Not that he has the ability to do so. Do you follow the question?
It shows that he has the, I think so, Your Honor. I think that it shows that he has the capacity to not essentially beat the victim up if he has the right motivation to not do that. And it's not, what we look at with that prong is irrational motivation. In rational motivations for crimes can come from jealousy, provocation, insult. Those are all rational motivations for crimes. When we talk about, the archaic term here, insanity, we're talking about irrational motives. And really here, that would just point toward the fact that she did find, and apparently she found what the motivation would be to get him to stop and to conform his conduct with the law, which would be to stop beating her. And I would just ask the court to take a look at a case that both myself and my brother mentioned in our briefs, and that is Commonwealth v. Lawson, 475 Mass 806, in which I would see it as far more favorable evidence on the defendant's part as to a lack of criminal responsibility. In that case, there was a defense expert who definitively opined, unlike the defense expert here, on all prongs that the defendant lacked criminal responsibility. There were police officer witnesses that testified in that case that the defendant was, quote, absolutely manic when he was assaulting the officers. And again, the Commonwealth provided no expert in that case. And the court came to the conclusion, and also in that case, the defendant was immediately arrested, taken to MGH hospital, where he was medicated with antipsychotics and described as paranoid or exhibiting paranoid delusions. And in that case, the court did find that the Commonwealth proved criminal responsibility beyond a reasonable doubt, despite all of that evidence essentially weighing against the Commonwealth. So I would just ask the court to.
But in that case, also there was statements by the defendant shortly after he was taken that he had that he was afraid that he would have to go back to jail. Understood that he was dealing with police officers. Fought the officers because he wanted to escape rather than be arrested and go back to jail. We don't have similar evidence in this case.
Well, I think in that case, what he said to the expert evaluator in that case was that he thought that the people that were coming after him were essentially either construction workers or security guards. I don't think he ever actually thought they were police, but he did indicate that he thought that they were trying to take him back to jail. Is it rational to think that a construction worker would be taking you to jail? I would think maybe not the most rational. And I think the issue there was that what the court found was essentially that he was essentially fabricating and downplaying his role. And that he didn't know he was assaulting police officers there. But I would note that the evaluator, in her opinion, essentially took his words as credible, where in this case, we don't even have a version of events from the defendant really, besides the fact that he's saying he really didn't do anything at all.
Well, but that surely is not part of the calculus, right? I mean, it's part of the calculus for his expert, but what the defendant doesn't have to testify. I mean, I'm really struck by this quote from Chief Justice Hennessy in the Cosca case, which is cited in Lawson, right?
Yep.
The Commonwealth runs a very real risk of reversal in the granting of a new trial if it chooses to rely on the presumption, at that point, the presumption of sanity, which is they do away with in Lawson, and the circumstantial evidence of sanity. That's exactly what the Commonwealth did here. They relied entirely on circumstantial evidence of sanity under circumstances where the only expert in question said, clearly this person was mentally ill and was having a manic episode.
I think in every case, essentially, we're relying on circumstantial evidence. Nobody can actually get inside the brain of the defendant.
You could have an expert opine.
I'm sorry?
You could have an expert opine. You could get an expert and have the expert opine as to whether or not he was mentally ill and could meet the other two prongs. Commonwealth chooses not to do that, but to do exactly what Justice Hennessy has described in that statement, which is quoted with approval in Lawson. And this is a case where that is exactly what happened.
I would dispute that. While the Commonwealth does not need to present expert evidence here, and that we can, and there's plenty of case law that suggests that we can look at the circumstances, improve our case through the circumstantial evidence here. And this whole runs a risk or it's perilous to continue without such really just means that the Commonwealth might have a harder time proving that burden. We didn't have that here because we did prove the burden, and all these inferences again are.
That's not true, counsel. You could view it, and you have indicated to me that the Commonwealth views it as just being a question of satisfying the burden of proof before a finder of fact. But the statement I just read you from Justice Hennessy indicates that you run the risk on appeal as well, or with the judge as well. You run the risk of not proving your case to the satisfaction of the courts. So it is not true that it's just that other risk.
Of course, we always run the risk of not being able to prove our case and of not upholding convictions on appeal. But here, I just don't think that that's the case. The judge as fact finder here, this isn't a case where this court or my brother substitutes its judgment for that of the fact finder here and determining the credibility of the witnesses of both the expert and the victim that testified here. I would also suggest, just as a procedural matter, as we bring up granting of new trials, that while it's unclear exactly what relief my co-counsel, or I'm sorry, my brother asked for here, that should this court come to the conclusion that the defendant, that the Commonwealth did not prove its burden, I think that would result in a finding of essentially NGRI.
I was just reading you the quote from Chief Justice Hennessy. I understand your point.
No, I understand. Right, and this would need to be, at that point, that would trigger Chapter 123, Section 16A and 16B, in which the Commonwealth would have a right to move for both an updated evaluation as well as commitment to a mental health facility in that case. So it just reminded me that I did want to bring that point up. And I do understand and respect your Honor's point.
Counsel, I'm sorry to interrupt you. Counsel, I'm sorry, but your time is well past. So I'll let you give you 10 seconds to conclude, and that's it.
I would just ask that this court affirm the judgments of the Cambridge District Court, and I would rest on my brief.
I'll just check. Any further questions from the other justices?
No, thank you.
Thanks to both.
All right, we are live.
Good morning, counsel. We're calling the second case on the list today, 2019 P1449, Commonwealth v. Santos. I'll remind counsel that each side has 15 minutes to argue. Usual appeals court rules are in effect. There's no rebuttal. Also, this case is being live streamed, so you are A, being recorded, and B, this is live, so please act accordingly. And finally, I'll remind counsel that this case is partially impounded, so please refrain from using any names or materials that are subject to the impoundment order. We'll hear first from counsel for Mr. Santos, Attorney Rubin.
Good morning. May it please the court. My name is Eric Rubin. I represent the defendant with respect to his conviction for a trespass. This is, out of the 3 charges, this is the only one that he was found guilty on, and as you know, that matter was filed. I have not been in a position to do this before this court, but I need to advise that there is a preface on my brief in accordance with Commonwealth versus Moffitt.
We saw it. Thank you, Your Honor. Or thank you, counsel. Excuse me.
Thank you, Your Honor.
Old habits die young, sorry.
Fine. Thank you, sir. As a result, I must admit, this will not be a lengthy process from my point of view, although obviously I'm happy to entertain any and all questions that the court may have. But ultimately, the argument that we are putting forth is that the trial judge erred in denying the defendant's motion for a required finding of not guilty. My client stated in his testimony, and he did testify on his own behalf, that he was seeking to do good while he was there. He was seeking to gain permission, and he was thwarted in those efforts and then ultimately arrested.
So generally, when a case is filed after conviction, as a general rule, there is no right of appeal. Is that correct?
That is my understanding, Your Honor. That's one of the, yes.
So at trial transcript page 101, it seems that trial counsel for your client sought this very disposition, sought to have this order of guilty filed enter rather than the harsher method of imposing an actual sentence. So the fact that this result was sought, how does that impact your argument?
Well, usually a filing, it's important to be clear what guilty filed really means. Guilty filed is a strange disposition, which means we're not going to decide. It means we're putting this off indefinitely.
It's typically viewed as a very favorable disposition for a defendant convicted of committing a crime, right?
It's hard to argue against that position because the only other opportunities are for the judge to enter a judgment notwithstanding the verdict, I suppose, on his own or her own, or it would be possible to make a sentence of time served when time has been served, thus ending the case. But
or to impose a sentence of probation, or to impose a sentence of incarceration.
I'm sorry, I missed the beginning of your.
I said, or the judge could impose a sentence of probation, right?
That is correct. There could have been probation, and the judge didn't do that. That is accurate.
Theoretically, there could have been a sentence of incarceration, correct?
Theoretically. So there's no question it's a favorable result. And again, I find myself in a strange position given the nature of my brief. However, it is interesting to note that guilty filed doesn't have any statutory, and by the way, Your Honors, I reviewed this case specifically thinking we might be talking about guilty filed because honestly, I was wondering why we were here. I don't mean that with any disrespect, but I could see that this court specifically has talked about guilty filed being non-statutory and somewhat ambiguous. And I don't know if the court is seeking to make some clarification of its position or talk more about what a guilty filed is. But it really—
You describe more cohesiveness perhaps than you should.
Well, in essence, guilty filed seems to be the equivalent of one's kitchen drawer, where we put things we don't really know where they go, and we're gonna maybe need them, but we certainly don't need them on a regular basis. And I don't mean to be flip with this, but it has been used, especially.
That's very good, counsel. That's very good.
Thank you. And I think, there is nothing inherently wrong with giving a district court judge the opportunity to show leniency and compassion in a situation that merits it. This case, there are many cases that are interestingly brought by the Commonwealth, given the time and resources that the Commonwealth has. And perhaps certain district court judges feel that it is best to give this type of disposition to not further time and expense and truly make an effort at judicial economy.
So would it be fair to say that the guilty file resolution is something that is a vestige of common law and has been questioned as to the basis, but it has never been held to be inappropriate or unconstitutional?
Absolutely.
Is that accurate?
I would say that's accurate. And nor am I seeking today to have it deemed unconstitutional.
Understood.
Equivalent of the pocket veto. Can I ask, because the other two folks on this call from my side know this much better than I, when it's filed, does it have a time limit to it, or is it sort of in perpetuity?
I read the case law on this, Your Honor, and it appears that the holding is that there is no time limit. And in practice, because I have been at this for back before my hair was this color, I've seen a lot of guilty files in my practice, and there's never been any change in the status of those cases going back for decades. It's extremely unusual. And the only cases that we, both my brother and I, cite with respect to guilty filed, talk about it in much as an aberration, in that someone is seeking to go back for ancillary purposes. I have to admit, I don't remember the holding. There's two specific cases. There's Simmons, I believe, and there's another that my brother cited. And they really don't go to the heart of what do we ultimately do with a guilty file, because the cases were decided in other ways. So the courts have never, in my experience, said, you have 30 years, or you have until the statute runs on this particular matter from when the toll date is or when the start date is. And none of that have I seen in the case law or anywhere in the general laws.
I just have one final question for you, and that is, hypothetically, were we to agree with the Commonwealth on this case, that no relief should be granted, is the correct result to affirm the conviction in the guilty filed, it's not a sentence, but the guilty filed disposition, or is it to dismiss the appeal?
Your Honor is asking me which form of execution I would prefer.
No, I'm asking which is required by the law.
Well, if I'm
there's a significant difference there, at least for us.
If this is the 80s and I'm back at the Cardozo School of Law and you are asking me as a student, I would say that you need to dismiss this appeal, because the very nature, if the Commonwealth's argument is accurate and that my client does not even have a right to appeal from a guilty file, then I would think you would have to strike the appeal. That would be my take on it. But of course, that's not our position. Our position, of course, is that my client was wronged, and because of his—
The concept is there's no final judgment in a criminal case without a sentence, and a filed is not a sentence, right? That's the concept in the case law?
That's what the case law says, Your Honor. We could, however, take this opportunity to boldly claim new ground and say that guilty filed is in fact a disposition, Because since there's no
Is in fact a sentence.
I'm sorry, Your Honor?
Is in fact a sentence. The way the cases are written, sentencing is part of the criminal process, and until there's a sentence, there is no final judgment.
That's true, Your Honor, because you could argue it is a sentence because sentencing is by definition what the court does after a determination of guilt is made.
Yeah, but a sentence that has an indefinite time period to it sounds very, very troubling.
Well, the Commonwealth often has guilty pleas that result in continued without a finding. However, as to your point is, Your Honor, there is often a termination date for that continued without a finding.
Yeah, exactly. Right? I mean, isn't a quaff usually it's got a period, continued without a finding for a year? Right?
That's
they don't do that when they file it, apparently. They just file it.
My experience is they do not. Now, that doesn't mean that someone has a different experience, and I don't want to invalidate it, but I can only speak to my experience and the case law that I've seen. And then the law that I have seen, there's been no time limit with respect to a guilty file. And if there are no further questions from the court, I would simply rest on my brief and thank you very much.
Seeing none, thank you. We'll hear from the Commonwealth.
Good morning, Your Honors. May it please the court. Chichili, Assistant District Attorney for Middlesex on behalf of the Commonwealth. The defendant was convicted of trespassing. The case was placed on file. This court generally does not consider cases placed on file unless they present exceptional circumstances. And the question of sufficiency is not one of those. Yes, Your Honor.
Counsel, can I interrupt?
Yes.
Let's put a finer point on it. Are you aware of any case where the only disposition was to place something on file wherein this court accepted an appeal?
Yeah, yes. So for example, in Commonwealth v. O'Brien, it would be 30 Mass Appeals Court 807. It's a 1991 case where the judgment was placed on file, but the court reviewed the case because there was an invalid search warrant that applies to all counts in that case. And that's when the court reviewed a conviction placed on file. That's one of the exceptional circumstances where the SJC has talked about.
But there were other counts. In that case, there were other counts that had not been placed on file. Yes or no? I'm not sure.
No, Your Honor. The entire case was placed on file. The idea of exceptional circumstances is where there's a legal error that applies to the entire case. Or there's another case in SJC that's Commonwealth v. Courtroom, which is 431 Mass 21. It's a 2000-year case where there was improper exercise of a peremptory challenge that affect the entire process. Now, those are the exceptional circumstances where the SJC has talked about when this court or the SJC will review a conviction placed on file. And to Justice England's question earlier to my brother about the time limit, criminal rule procedure rule 28E did talk about how to place something on file. And in district court, sometimes judges will place 10 minutes time limit or a day. I've seen those happen. It really depends on the court's disposition. So there is a time limit to it. And when the filing itself is not rule compliant, this court recognized that the defendant would have a right to appeal a conviction. That would be Commonwealth v. Delgado 367 Mass 432. It's a 1975 case. So if a guilty file is in compliance with the rule, this court's remedy given to the defendant is to review the conviction. And that could be one of the things that the courts can do here is review the sufficiency argument where the evidence actually at trial showed that the defendant committed trespassing here.
Counsel, I'll ask you the same question I asked Attorney Rubin, which is, what is the correct, if we agree with the Commonwealth, what is the correct disposition from this court and why?
So in Prussia, which is a SJC case I cited in my brief, where the court talk about placed on file, it's not a final judgment and the court cannot review it. And this court, the appeals court, constantly dismiss cases where there was cases placed on file. If the court goes through the docket the court has, you can see the court systematically dismiss cases where it's placed on file. So the correct remedy here would be dismiss the appeal.
Dismissed on what basis?
There's no final judgment because there's no sentencing.
I'm not finding where in Commonwealth against Calderon that it was, that his, how do we know that that was filed, that this conviction was filed?
It's one of the cases that it was discussed. I can file a Rule 16E letter if the Rule 16 letter to.
I mean, I can read. I just can't see. It's not jumping out at me that they addressed that. It must be in a footnote somewhere that I'm not picking
Right. So
up.
it's not entirely clear, and it's a pretty long case. I'm sorry, I don't have a clear sight to Your Honor. I could file a 16E letter if Your Honor prefers. But O'Brien will be a clearer case where the court did review it. And even if the court reviews this case.
What's the of O'Brien, 30 Mass Appeals? What's the rest of that?
807, and you can see in footnote 1.
Anything further, Commonwealth?
The one case that you cited, the case Judge Barry's opinion, there were convictions that were not placed on file, and so that's not very helpful to me.
Yes, Your Honor. But if this court were to review the defendant's merits of the case, which is sufficiency, the evidence showed that defendant was they entered the ecumenical center of Framingham State University and was asked to leave by police twice, and the defendant refused to leave and remained the center. And the evidence showed that it was trespassing. So even if the court were to review the merits of the case, this court would affirm.
O'Brien's a different case again. I'm sorry to interrupt, but O'Brien, yep. there were 2 charges, one of which was a drug charge on which he was convicted and was not placed on file.
Right.
So I'm still looking for one case where when the only conviction was placed on file, where we've accepted the appeal. I as of yet haven't found it.
That's correct, Your Honor, and that's my understanding. I could not find a case where the entire case was placed on file, like all the charges are placed on file, where the court reviewed a conviction. And this is one of the few cases that come up here where there's only one charge and was placed on file, and the defendant is asking the court to review the sufficiency of the evidence and ask that this court dismiss the appeal because the case was placed on file and there was no final judgment.
So your brother says, and I'm only going to prolong this for a moment or so. Your brother says, maybe it's time to be bold and realize that placing it on file is a final judgment, just like all the rest of them. What do you say to that? I
was not prepared to answer that question, but argued that if this court were prone to adopt that line, the limitation should be whether there was a time restraint. If there was a time limit imposed by the court and that time has expired, that could theoretically be considered as a final judgment. However, that's not the case here.
Wow, I mean, that to me goes against all my instincts. All of my instincts are it's much worse if the outcome of the case is an indefinite limbo with respect to the charges, so that they could apparently be, if something happens, then the Commonwealth has this additional tool in its toolkit that they can bring the guy or woman, whoever it is, back in and say, hey, remember that thing that was filed? Now it's time to sentence them because they did this. That seems to me to be exactly what we don't want.
Right. That's why Rule 28E requires both the Commonwealth and the defendant's consent to a guilty file. And in this case, as Justice Neyman pointed out, it was the defense counsel's request to place it on file in transcript 101. So that's a different situation, and that would not be the court's concern in this case.
Yeah, thank you.
Check with the panel. Any further questions from either of the justices?
No, thank you.
Seeing none, the case is submitted. Thank you, Commonwealth, for your excellent argument. And Attorney Rubin, thank you very much. I know this case was submitted pursuant to Moffitt, but you made an excellent argument and your per side. There is no rebuttal. And of course, this matter is being live streamed and recorded. With that said, we'll hear first from counsel for the defendant appellant, Attorney Cox.
Okay. Good morning. May it please the court, Jennifer Cox on behalf of Mr. Carrington. Mr. Carrington is appealing 2 convictions from Middlesex Superior Court one of larceny and one of attempted larceny. Mr. Carrington's first argument on appeal concerns the admission of hearsay statements in recorded telephone calls from him to his mother and to customer service agents at Citibank who did not testify at trial. The court overruled his objections to the evidence, denied his request to redact the hearsay statements, and also denied his request to give the jury a limiting instruction, resulting in prejudicial error. The statements here were relevant only for their truth, that the defendant's sister was in desperate need for money to pay an overdue account, a home equity account at Citibank of a certain number, and that the bank could only process payments in increments of $10,000, resulting in the $10,000 and $5,000 increments. The defendant.
Counsel, I'm sorry to interrupt, but isn't there a long line of cases in Massachusetts that says that when a defendant's statements are being admitted because they're admissions, that the other side of the conversation is also admissible to show context and essentially to make sense of the defendant's statement, without which the defendant's admissions really provide no assistance to the finder of fact? How, in other words, that's a long way of saying,
No, I understand.
Isn't your better argument here that there should have been a limiting instruction?
Yeah, absolutely. And I can move on to that if you'd like, but just as far as I think what you're talking about is the verbal completeness doctrine. And here I would just say, if you, as the Commonwealth argues in its argument for why there was no prejudice, they argue that the statements we're complaining of were cumulative of other evidence. So just as far as the verbal completeness, I would say it can't both be cumulative and necessary to inform the other part of the conversation.
Really verbal completeness, or is it something different that they're not?
They're stealing my question again. All right.
Oh, sorry.
No,
I knew that. I knew that.
No,
Judge Neyman, please, you have the floor.
No, well, that's exactly no, and Judge Englander and I have been doing this all month, so.
Yeah. Yeah, so that's
not just verbal completeness, it's context. There's any number of reasons why it's admissible, correct?
Well, obviously the defense would disagree with that, but I do understand your point. I would just say that the specific remarks that we're complaining about, I don't believe fit that. But I certainly, as the Commonwealth says in their brief, certainly where the
there for a moment, when you say the specific comments that you're complaining about, I had a little bit of difficulty pulling out of your brief what those were. So can we just start with the fourth call, which is the call with Citibank? The EDA says, hey, there is nothing in there that's hearsay. It's all questions. Are there particular components of what was said in the fourth conversation that you believe should not have been admitted?
Yeah, as to the fourth call, it was the statements, and I agree that with the Commonwealth that when the representative is asking questions, that's not a question, is not a statement. But in the fourth call, which is the most important one, is where the customer service agent explains, well, we can't do it in 15,000. We have to do, by bank rules, we have to do 10 and 5. And so that's the main thrust for that call. But to
that statement there, you would say that's a statement, not a question, and it's hearsay. It's a statement being offered for its truth.
Right.
The response to that would be, it's not being offered for its truth. It's being offered to show context, if you will, for what the admissions were of your client. And what do you say to that?
Well, I don't think it's necessary to I think there's still a requirement that for it to come in under that rubric, that it needs to be necessary to it, because it is still hearsay. So just our position is that it's not necessary when you take into consideration the rest of the comments, including the defendant's comments. I can move on to Justice Neyman's question about the limiting instruction if there's no further questions on that issue. Certainly, I would agree that I think that's where the evidence is sort of arguable, that the lack of a limiting instruction really is the worst part of the defendant's the best part of the defendant's argument. So here I would point the court to the two cases cited in our brief, which are the Dean case and the Purdy case. So Dean is the one that's most like this case, where it also had to do with jailhouse calls from the defendant to a friend and to the friend's boyfriend. And so that included hearsay. And so the defendant on appeal was appealing not just those hearsay statements, but also his own statements on it, which is not relevant for our purposes today. But as far as, so the court.
Am I correct? I'm sorry, am I correct that in Dean, though, there were several errors? Not just,
Yes.
not just the one error about admitting hearsay without a limiting instruction?
Yes, correct. Yeah, so in Dean, the court's discussion of the hearsay was very brief because they spent more time discussing the defendant's own statements, which again, not an issue here, but the court noted that where the trial court gave a limiting instruction, this showed that the court was cognizant of the potential for prejudice and remarked that this was the appropriate way to deal with a hearsay issue. So our argument here is that we also, if they were going to come in, they should have still gotten the instruction. Also, the Purdy case, which was the prostitution case, where they found that the statements were verbal acts, essentially, regarding the prostitution, but said that to the extent that the jury, that certain statements could have been understood by the jury to have been offered for the truth of the matter, that denial of the request for a limiting instruction was error. They did go on to find no prejudice, but they did find error there. So here we're arguing.
As I understand it, the defense in this case was essentially, the Commonwealth hasn't proved that the voice on the telephone was that of your client. Is that correct?
I think that's accurate. Mm-hmm. It was a combination.
Yeah, so it was an ID case. Is that right? Effectively?
Yeah, they argued that, and also that Ms. Lima was not credible and was seeking that. So it was kind of a bit of a smorgasbord. But I think that's true, that was the thrust of it, was that they didn't prove that it was him. They didn't prove that it was the mother on the phone. Yeah.
So if those were the defenses at trial, why is there prejudice in allowing in this information?
The defendant's position
that it doesn't cut to the heart of your argument, but perhaps I'm mistaken.
Right. No, and I also note, we're not here on a sufficiency argument. I'm
Right.
not arguing that it made up a shortfall in any of the necessary elements of the offense. But as cited in the brief, I think it does go to the motive. And as the Cruz case said, it filled gaps in the evidence, not as far as the elements go, but as sort of the Commonwealth's painting of the picture of how this came about, of what the reason for doing it, what the motive was. So that's our best argument on that, is that it went to motive.
But in the fourth call, he starts off by saying, "I got to pay this bill for my sister."
Right.
Right.
So if that's the case, that goes to whether this is cumulative, or whether under verbal completeness that it's necessary the hearsay is necessary to give context to the rest of the conversation. I would say where he's making those other statements, it doesn't give context to the rest of it, because that's already in there.
How do we know, without the statement in the fourth call, "Welcome to Citibank," how do we know who he's talking to?
As far as the hearsay that it's the Citibank, I believe there's his statements in previous calls to, or maybe earlier in that call to Lima. I think he may say, "I need you to call Citibank." So I think that comes in from other sources. I'm happy to move on to my second argument, unless there's anything else you'd like me to explain from that one. But the second argument goes to.
Stay on the first argument for a moment. The Commonwealth concedes error. They say a limiting instruction should have been given. And the limiting instruction, had it been given, would have said that the statements not made by the defendant are not being offered for their truth. Is that the limiting instruction that we are
Yes.
looking for?
Yeah.
Okay. And how were you, articulate for me how you were prejudiced because that was not given?
As I said, I think it's just this case, as in the Cruz case. I think there's 2 Cruz cases cited in the brief, so this would be the appeals court one. Says that where the prejudice can come from, whether it expands. Let me make sure I got it. It's not merely cumulative of properly admitted evidence, but rather expanded on the evidence. And here it provided the only evidence of the motive for the crimes. So again, like understanding we're not here making a sufficiency argument that the Commonwealth's evidence fell short, and considered in the light most favorable to the Commonwealth on the elements. So mainly it's that it provided context and motive that wouldn't have otherwise come in. So I can be brief on the closing argument issue. So the Commonwealth made a statement in closing. The exact comment, the whole context of it obviously is in the brief and in the transcripts, but the remark is, in order to be prosecuted, you have to do something wrong. So our argument is that this is improper in 2 reasons. One, that it vouches for the credibility of Lima, their own witness, and second, and more importantly, that it serves to vouch for the guilt of the defendant, saying in order to be prosecuted, you have to do something wrong, intimates that because the prosecution used its prosecutorial discretion to indict the defendant, that means that they have knowledge that he did something wrong and that the jury should rely on that. And just to make sure I make the point, so in the Diet case, which is our best case on that, but I would also just like to briefly say, as my brother pointed out in the brief, my brief, unfortunately, I apologize, does misstate the holding from that case. The holding was a suppression case, and the holding had to deal with that. But where the court considered here, it was a statement, because we don't know, we don't charge, followed closely by the remark, what we do know. The court there found that this constituted vouching because the prosecutor was inviting the jury to rely on the prestige of the government. And it suggested that because the Commonwealth charged the defendant with a certain offense, it had superior knowledge than the jury did of that. And just
wasn't the comment, in order to be prosecuted, you have to do something wrong, directed at the cooperating witnesses' testimony?
In Diet?
No, in the present case.
Meaning Lima is the corroborate. I gotcha. It was directed at that, but I think had it been phrased differently, we wouldn't have an argument. Like if the introductory language had been more specific to her, and I can't. Where the remark is, you'd have to be, you'd have to be, in order to be prosecuted, you have to do something wrong. So I think if it had been specific, if it said Lima, in order to prosecute Lima would have to do something wrong. There was an objection, so I guess I'd have an argument to make just because it was preserved. But I think that here, where it says you have to do something wrrong, that means anyone, and including the person sitting before you. Mm-hmm.
Doesn't that beg the question? Lima was given a promise not to prosecute, correct?
She testified. It's the record on that is very confusing. So the Commonwealth answered that she was not given one. Then when she testified, she said she was. And for there, I would cite to the cases that say it's a witness's understanding of whether they are getting a benefit or whether their expectation or hope that is important. So I don't know that answered your question.
So in discovery, when the Commonwealth was obligated to disclose promises, rewards, and inducements, there were none disclosed?
Correct. Yeah. But for that, and the defense attorney twice filed motions asking that, and twice the Commonwealth answered that there were none. Then the defendant, when asked that question, said she did. So the defense attorney
corrected, wasn't there a correction to that later in the testimony?
I don't believe so. Lima testified, then she made remarks saying, I've done nothing wrong, so why would they? But that was stricken. So I wouldn't say that there's a correction on that. I don't know what happened here. I do suspect that if the defense felt that the Commonwealth was being deceitful about whether they had offered one, there would have been
raised
or mistrial or something like that. So I think maybe just answering that she had.
Now you've piqued my interest on something else. The introductory sentence before the sentence that you fix on, right, the prosecutor says words to the effect of, it's just like she says, or I think it's like she says.
Right,
which could be very problematic, except that, as the prosecution points out, it appears that what he's referring to is the statement you just mentioned, where she said, in order to be prosecuted, I have to do something wrong.
Right,
So
which was,
why is that? I mean, if that's what all the prosecutor was saying, was hearkening back to her testimony and saying, like she said, in order to be prosecuted, she'd have to do something wrong. Isn't that entirely appropriate argument?
well, I would say for two reasons it's not appropriate. One, her comment to that was stricken, so that's not, I don't think it's fair to respond to that in closing where it was not part of the evidence. And
So
second,
that statement that he apparently adverted to had been stricken from the record.
that's my recollection, that it was stricken. Certainly my brother can correct me if I'm wrong on that, or I will look and do a 16L letter later. But the second part of that, just I see I'm out of time, as I said, I think the worst problem is than the vouching for Lima's credibility is the intimation that because we indicted the defendant, that means he did something wrong. The cases speak for themselves on that. So unless there are any further questions, I'm
No need for 16L, by the way, on that. We can look it up ourselves.
all right. Thank you very much.
Seeing no further questions, we will hear now from the appellee, the Commonwealth. Thank you.
Apologize, I've unmuted now. All right. Good morning, may it please the court. Assistant District Attorney Jamie Michael Charles from Middlesex on behalf of the Commonwealth. I do want to start with the issue of the alleged hearsay, but just to clarify so I don't forget later, if you look at page 213 and 214 of the first volume of the trial transcripts, I believe that is where the witness, Ms. Lima, states makes the statements in question that are mentioned in closing. And I would submit that if you look at the transcript there, that particular statement was not stricken. It was some statements that were made on redirect. But to turn first to the issue of hearsay. As my sister mentioned, and as the court acknowledged, the Commonwealth does acknowledge that it was likely error here for there to not be a limiting instruction, at least as to the statements of parties who were not present, who were on the other side of the conversation with the defendant.
Was it likely error or was it error?
I think I said in my brief, it is error. I don't want to paraphrase whether it was error or not. I think I probably could have been a little bit clearer in my brief that there's sort of three different categories of statements here. There's statements the mother makes that are relevant to the financial situation of the defendant's sister, which go to motive. There are statements that the mother makes that are relevant to the actual information necessary to process the transaction, account numbers, bank, etc. And then there are statements of the city financial representatives on the phone. As to the first category, the statements the mother makes regarding the sister, I think there are two important points. One, I think was sort of touched on in the first instance during my sister's argument, which is that those are entirely cumulative. If you look at both what the defendant says at the start of the fourth call before he connects with Citibank, and if you just look at his side of the conversation in the earlier calls, his statements in and of themselves establish that his sister is in financial peril, that she needs money, that it has to do with a line of credit and an equity mortgage, and that he is attempting to pay it off. Those are all established through statements of the defendant. As I also mentioned in my brief, the truth of those statements is irrelevant. I don't want to say irrelevant. The probative value of those statements is not enhanced by whether or not they are true, right? Their value is that the mother tells the defendant something and the defendant acts based on what he is told. Whether what he is actually told is true or not, it's still the motivating factor that leads him to commit this crime. So whether or not it's true, he's heard the information and he is acting upon that information. So there's no additional probative value to the statements based on their truth. As to the second category, the account numbers, again, I would say all of that is given by the defendant in his statements to Citibank in the fourth call. And so it's entirely
Can I stop you there, counsel?
Yes.
Without the hearsay statement at the beginning of the fourth tape that this is Citibank, is there anything in the record that tells us it's Citibank?
Yes, and I'm glad that came up during my sister's argument because it allowed me to look it up. If you look at page 19 of our supplemental record appendix, which is the tail end of one of the earlier calls, the defendant states, the mother makes a statement, and then the defendant says, this is Citi Financial. So, and I believe there may have even been an earlier one, I wasn't able to track it down, but at a minimum there, the defendant makes a statement that references Citi Financial. I would also note that the automated message at the beginning of the Citibank call when he is first connected is arguably also not hearsay. And there were records of Citibank that were admitted into evidence, along with records from the victim's bank.
It's an out-of-court something being offered for its truth, counsel. You're saying it's not a statement because it's automated.
Well, I think that's debatable. So I don't think it's worth going down the rabbit hole. I guess I will say at a minimum, he mentioned Citi Financial in an earlier call. There are Citi Financial records introduced that show. I'm sorry?
You're saying a jury could reasonably infer from the total context that this was Citi Financial.
Yeah. I mean, I would go a step farther and say that I think it was abundantly clear from the evidence that this payment was made to Citi Financial, but certainly there was more than sufficient evidence on that point.
Before
Yes.
we get to prejudice, I understand the three categories, but the bottom line here is you concede that some of the statements admitted were hearsay and were admitted for a non-hearsay purpose, correct?
Yes, I do concede that. The defendant asked for an instruction, and the judge, although he did sort of reason out why he wasn't going to give one, probably it would have been better served by giving it. I'm not sure that the instruction the defendant asked for, as Your Honor alluded to during my sister's argument, would have accomplished anything for the defendant, though, because essentially what counsel for the defendant was asking for was simply an instruction that the statements made by other parties were not being offered for their truth. And again, as I mentioned, I think the vast majority of these statements that do constitute hearsay, their probative value was not enhanced at all by.
If you're conceding that some of this hearsay was not improperly admitted, but should have been subject to some form of a limiting instruction, and it seems patently obvious that a limiting instruction should have been given.
Yes. I'm not trying to split hairs. I do think there should have been a limiting.
Let me finish my question. Why didn't the prosecutor say to the judge, yes, judge, some of this is clearly hearsay. Not only do we not object to a limiting instruction that's being requested, please give one. And here's what you should say. Why would experienced counsel not make that? It's not even an argument. Not ensure that this issue was off the table when, as you're saying right now, it's really a non-issue. I'm really having difficulty in this particular case understanding why the Commonwealth, in my view, didn't assist the judge.
I mean, obviously, Your Honor, I can't get into the head of the trial prosecutor, but I do think that here, I guess what I would say is, Justice Henry, who was the trial judge, is also an experienced jurist. And it seems from my review of the transcript, because this was discussed at numerous points at sidebar throughout the trial, it seems as though both the prosecutor and the trial judge were under the impression that because this other half of the conversation was necessary for context to understand the defendant's statements and to understand his admissible admissions, sorry, that's an odd phrasing, that they were not therefore hearsay. And that is clearly wrong, but it seems as though both the trial judge and the prosecutor were under that same misimpression. And so they did not feel that.
Technically, if they're not being offered for the truth, they are not hearsay. But you should be entitled to a limiting instruction that says they're not being offered for their truth when one is requested, right?
I'm not disputing that at all, Your Honor. I mean, as an appellate attorney, we second seat trials quite often. And had I been present at this trial, I would have certainly advised that a limiting instruction be given. Again, for mainly the reason that I'm sort of arguing now, which is I'm not sure it necessarily really would have hurt our case, the Commonwealth's case, at all. The jury would have still been able to understand the conversation. The additional information would have been entirely cumulative and also not particularly enhanced by whether or not it was true or not. So there really wouldn't have been a downside here. And I do think an instruction should have been given. But I mean, be that as it, that's why the Commonwealth didn't try to attempt in its brief to suggest that everything was fine here. But I think the key point is that for most of the reasons I've sort of already stated, there's no prejudice to the defendant here, not only because these statements were relevant regardless of their truth, and then they weren't more relevant because they were true, but also because they were cumulative of properly admitted evidence that I would characterize as overwhelming. The defendant makes all the admissions that are necessary to convict him in the fourth call. The victim testified to discrepancies in the checks and that the defendant wasn't an authorized signatory. Records were introduced to show the theft. In terms of the identity issue that the defendant primarily hung his hat on at trial, his name preceded all of the recorded calls. The call log, his call list from the prison, which was admitted, that was specific to him, had Miss Lima on it, had his mother on it, had Kitty Carrington, his sister, on it. There was really no dispute. As the trial prosecutor pointed out. I'm sorry, Your Honor.
Nobody explained. I'm sorry to interrupt, but it's very disappointing to me that nobody explained how the heck he knew what to do here. How is it that he had the routing information and the checks from some institution that had never ever had any contact with him, according to them?
Your Honor, without going to, obviously we're limited by the record. I'm intimately familiar with this defendant. This was not his first rodeo. I will simply say that he's quite an effective criminal in terms of larceny schemes and forgery schemes. In fact, in a prior prosecution, he told the court that putting him in prison wouldn't stop him from committing crimes, and that proved to be true in this case. He was able to commit this crime from behind bars. So, but again, it's not the point being, we don't have that in this record, but what we do have is more than enough information to overwhelmingly establish the taking here through the records of the victim's bank, through the Citibank records, through the defendant's admissions in all of the calls, which I would submit, if you simply redact out everything else that was said by other parties and just look at what the defendant says in all these calls, you can still easily piece together both his motive and the actual crimes commission. So I don't think there was any risk here that the defendant was prejudiced by, while there definitely should have been an instruction, and I'm not quibbling with that, I don't think there's any evidence. There's nothing in this record to suggest that he was prejudiced by the lack of that instruction on these particular facts. Turning to the second issue, again, I just reemphasize that this was a statement that the witness made. And I do want to clarify this idea of, was there a promise not to prosecute? There was not. If you look at page 11 and 12 of the first volume of transcript, not only did the court refuse to appoint counsel to Ms. Lima because it concluded that she had no criminal exposure, the prosecutor said that it had never considered prosecuting her for any crime explicitly. I think that's at page 12. Then at around page 213, 214 on cross-examination, when she makes this one isolated statement that she was promised something, she immediately qualifies that afterward and says, wait a minute, I didn't do anything wrong. And then on redirect at page 216, the Commonwealth establishes that no charges were ever threatened against her. So while the defendant hung its hat on this one positive statement that the witness made on cross-examination, the record, the lack of any disclosure and discovery, the prosecutor's representations, the witness's clarification on redirect, all established that she wasn't, in fact, ever promised anything by the Commonwealth because she had no role. I mean, she was essentially, the defendant tried to make Miss Lima a bigger deal than she was. She was essentially a foundational witness who sort of established how the defendant conducted the scheme. It would have seemed odd to just introduce calls where he's talking to some unidentified individual and then gets transferred over. She also was useful in the sense that she established that the likely voice on the other end in earlier calls was the defendant's mother, which was relevant somewhat to motive, but she was not our smoking gun witness. I mean, the case was made through the defendant's admissions, through the documentary evidence that was admitted in the records, and through the victim's testimony that he had no idea who the defendant was. His business wasn't located at 40 St. Botolph in Boston. His business's name was misspelled on the checks. Like, there was abundant circumstantial evidence of what the defendant did. And I would also just note that I think here the prosecutor the second statement was grounded in the evidence. He said there's nothing in the evidence in this case to suggest that Miss Lima did anything wrong. It was in response to the defendant's, I don't want to say prolonged, but it was about a paragraph in his closing in which he tried to attack Miss Lima by saying that, I'm sorry, I want to get it right. That he tried to insinuate that she didn't walk away when she connected the defendant to his mother and to Citi, and that she actually knew what was going on. And he said, quote, she was trying to shift the blame from herself. And so the prosecutor is just rightfully, I would argue, responding that. Was it the most artful way to do it? I'm sure there could have been a better way, but I don't think it crossed the line into vouching or elevating the prestige of the government. This was the prosecutor using the witness's own words to sort of preface his statement that the evidence in the case did not establish any wrongdoing on the part of Ms. Lima. And to
excuse me for interrupting you, but isn't it
Yes.
problematic in any instance when you're having a discussion about the sort of cause and effect of prosecution and the wrongdoing that precipitates it, to suggest in a closing that generally, as a general matter, not necessarily specifically to Ms. Lima, in order to be prosecuted, you have to do something wrong? Is there not a problem with that fundamentally?
I think it probably was better left unsaid. And I think certainly if she had not explicitly said that exact thing during her testimony and the prosecutor had just made that statement as sort of an oratorical flourish, it's definitely more problematic and possibly crosses the line. Though again, I would still strongly dispute that it prejudiced the defendant in the context of the larger closing and the evidence in the case. But I think here, even though it probably was better left unsaid, where he's quoting what the witness said, and then in the very next sentence saying the evidence doesn't show that she did anything wrong, that in the context of this case was not him relying on the prestige of the government in order to buttress the Commonwealth's case. And I see my time is up, so I'd ask that you affirm the convictions, and if there are no further questions, the Commonwealth will rest on its brief.
Seeing none, the case is submitted. Thank you both for your helpful briefs and your helpful arguments and your excellent knowledge of the record. We appreciate it.
We are live.
So we are now calling our fourth case on the list, number 2019 P0962, VACCA versus Brigham and Women's Hospital. I'll remind counsel that each side has 15 minutes to present its argument. There's no rebuttal. And of course, this case is being live streamed, and you are being recorded as well. So please keep that in mind. And with that said, we will hear from the appellant, represented by Attorney Raphaelson.
Good morning, Jeff Rafelson on behalf of the appellant and VACCA. The case is about deep brain stimulation for treatment-resistant depression. DBS for depression is experimental psychiatric neurosurgery. It's at a proof of principle stage of development. It has not reached therapeutic status. Before the surgery, the parties understood that Ms. Baca might not benefit from it. Nevertheless, she agreed to be the first person, and it turns out the only person, ever to undergo psychiatric neurosurgery at the Brigham and Women's Hospital in the history of the institution. The device implantation procedure involves drilling holes into a person's skull, implanting leads into the part of the brain believed to affect emotion. The leads are then connected to a battery implanted under the collarbone. The battery powers the electric pulses delivered to the brain.
I'm sorry to interrupt you, but I should have said before that we have read the briefs. We are intimately familiar with the record, and we've reviewed the case law as well. So I don't think you need to go through the facts. We'd love to hear your argument.
All right. Well, there are three issues on this appeal, three main issues. Was there a binding oral contract between Ms. Baca and the hospital? Was it breached? And is there sufficient evidence to get to a jury on the claim of intentional infliction of emotional distress?
So with that in mind, when was the contract formed, and what were the material terms of the contract?
The contract was formed before the device implantation procedure in July of 2012. And the material terms of the contract was the hospital said to Ms. Baca, if you are willing to be the first ever psychosurgery patient here at the hospital, we will pay for all the costs associated with the psychosurgery, all the costs associated with the device programming and the battery exchanges for as long as you continue with DBS. And Ms. Baca said, fine, I will do that. I accept that. And I agree to undergo the surgery. And she did that in July of 2012. So there was an offer.
Wasn't it actually your client that made the offer, or at least solicited the work of the hospital?
I don't think that necessarily is material. I don't think that that's necessarily the case. But the offer, there's offer and acceptance, right? The parties come together and they agree that there's going to be this neurosurgery and that she's going to undergo this novel procedure. And there's offer acceptance and there's consideration, and the consideration for the hospital was that if that they had an opportunity to promote, to create and promote a new psychosurgery program, and to promote itself as experienced in this new field, so it would be in a position to profit if DBS proved to become effective treatment for depression in the future. And the detriment to Ms. VACCA was that she undertook the substantial risk that the novel procedure might not work or that she might suffer complications as a result of it. Now, in Massachusetts, under the marine contractors case, Mass law does not require both benefit and detriment. Benefit to Brigham and Women's or detriment to VACCA is enough under Massachusetts law. So there's a binding contract because there was offer acceptance and consideration.
So can we move to breach then? I'm sorry to interrupt, but can we move to breach then? I've written down the terms that you just identified of this agreement. How was it breached? You've given us four different posits of how it was breached, right?
That's right.
And which ones do you want to talk to us about today?
Well, I want to talk about all of them, but
okay.
But I want to preface it by saying that there's a fundamental disagreement about what the terms of the contract mean. Brigham and Women's Hospital argues that its promise to provide and pay for Ms. VACCA's DBS programming and battery exchanges did not mean that it promised to staff her case with someone qualified to program her DBS device or promised to provide any DBS care to any particular standard whatsoever. It argues that it was free to staff her case with an unqualified programmer, free to ignore professional norms, which are the existing scientific and ethical standards.
Can I stop you there? This goes to your second allegation of breach, essentially a failure to have appropriate support, right?
Well, it goes actually to all of the arguments except for the argument on the letter agreement. Because what they're asking the court to do is, as a matter of law, rule that the contract unequivocally provides this freedom to not staff her case with a qualified programmer, to ignore existing professional norms.
Counsel, if I could, there's an awful lot of, in both briefs, trying to cast and recast the allegations that are made. But if I could, medical malpractice, as we understand it, arises from contract. It has become a tort, but it arises from the fact that the physician and the patient have an agreement to actually provide some kind of treatment. And how is what you're arguing now different from the arguments that were made historically that we treat as medical malpractice, which are, you did not meet the standard of care of a physician or doctor under the circumstances?
Because Ms. VACCA's claims, there's three reasons. One is Ms. VACCA's claims of breach involve intentional conduct of hospital administrators or involve non-medical activity. None of the claims involve a breach of the medical standard of care by a healthcare professional. The hospital administration decided to authorize Dr. Cosgrove to implant only the free standard battery and not to pay for a rechargeable battery, the 2015 battery exchange surgery. That's not a medical judgment, because Dr. Cosgrove's medical judgment was to implant the rechargeable battery.
How is the type, I'm sorry to interrupt you, how is the type of battery, whether it's a rechargeable battery or the replacement battery, a material term of the contract?
Well, the material term of the contract is to provide and pay for all the battery exchange surgeries and all the expenses associated with the exchange surgeries.
Did the agreement say that the hospital says? Did the agreement say that your client could choose the type of battery?
No, but and she's not complaining about the decision to implant. Her complaint is with the is with the administration's decision to avoid the expense of the DBS service it agreed
No,
to
the
incur
administration
sick
didn't
under
decide to
circumstances
avoid-
that put her health and safety at risk.
Counsel, sorry, because of the situation we're in, where it's very difficult, we're going to talk over each other. If you hear us want to ask a question, I'd appreciate it if you just allow us to ask the question.
Yes.
With respect to this, it's not a decision not to do it. It is a decision to implant a particular battery, right? And how is it that the contract contemplated that there was an obligation to, if you will, continue to move with whatever happens in the field after 2012? Or put another way, is it your contention that that was a term of the agreement that they would have to improve as the field improved from 2012 forward?
Well, I don't know that it's a function of the field improving, Your Honor, so much as it's a function that there was a recognition that because of in 2013 and 2014, Ms. Baca suffered severe depression around the battery exchanges, that she was concerned about the annual exchanges posing a risk to her health and safety, and the certain neurosurgeon shared that concern. And for that reason, he wanted to implant a rechargeable battery with a many-year life expectancy so that he could avoid
the rechargeable battery cost 100 times as much as the battery that they'd implanted the couple times before. Is it your contention the contract required them to incur whatever expense was appropriate, I guess is the word you would use?
Yeah, I think that this is, fundamentally, this is about the covenant of good faith and fair dealing inherent in the contract, and that Ms. Baca had a justified expectation under that covenant that the hospital would not put her health and safety at risk in order to save the expenses associated with DB service agreed to incur, and that's what they did.
She could always have decided not to go forward with her treatment, right? That was always within her realm.
Well,
so the hospital continues to do what they were doing in 2012. She doesn't like it. It was always within her realm to decide, okay, I'm going to cease treatment.
Well, it wasn't, because by that time she was dependent upon DBS, and if the stimulation was interrupted, then she risked dying. I mean, there was in 2013 and 2014, around those exchange surgeries, when there was any interruption of the stimulation, she had a recurrence of severe depression. In 2014, she ended up in a hospital with suicide ideation.
So that's an argument that argument sounds to me like is saying that the hospital took on whatever cost they might have to incur in order to maintain what you believe or what your client believes was appropriate treatment for the rest of her life.
Well, they did in fact do that. That's what they agreed, and that's set forth in the proposal from Dr. Erb to Ms. Sinclair, where it reflects the cost and the annual cost, the likely annual costs, and the total was estimated at around $1 million. They understood that what they were.
But I'm asking the question of what if you're saying the treatment now has changed. In 2012, 2013, 2014, they gave a battery that was not rechargeable. You're saying they incurred an obligation in that 2012 contract to change the battery and incur additional costs.
Well, it was nominal additional costs. So the rechargeable battery was not materially different costs than the standard battery. What happened was that they got a free standard battery from Medtronic. They applied for a free standard battery without talking to the clinician, and they didn't have enough time to get a rechargeable battery free. They didn't have enough time to get a free rechargeable battery. They would have had to pay for it, and they would have had to pay essentially the same amount of money that they were paying for a standard battery, but they didn't want to pay for it at that point, because by that point in time, they had abandoned their effort to develop a psychosurgery program. They had left Dr. Tian, he was no longer there. They had designated Richard Fernandez, an administrator of the hospital, to manage the costs associated with Ms. Vaca's DBS. And one of the things that they did was try to get a free battery from Medtronic. They got the wrong one. The clinician said it's the wrong one. They didn't have enough time to get the right one for free, and they didn't want to pay for it. That's a breach of the covenant of good faith and fair dealing, putting her health and safety at risk in order to save expenses associated with the DBS service agreed to incur.
You do
So that's
see
the issue on the battery.
You do see how everything you just said really sounds in a medical malpractice claim.
It may, but here's the reasons why the malpractice statute doesn't apply. First, we're talking about conduct of a hospital administrator. The hospital administration, the law is crystal clear that if it's administrators that are at issue, their conduct, then the medical malpractice statute doesn't apply. And
Even
so,
if they're making medical decisions? I mean, how does the law draw the distinction between when somebody is acting as a hospital administrator and when someone is making medical decisions on behalf of a hospital?
well, but this certainly, the battery certainly wasn't a medical decision, because the medical provider, the neurosurgeon said, I think that the best interest of this person is to implant a rechargeable battery and not a standard battery. So it wasn't a medical decision.
You can say it's not a medical decision when in the same breath you say that the reason that she was harmed is because she had a medical need that wasn't being met.
Well, it's not. First of all, this is human subject research, and not medical care, and the statute doesn't apply to human subject research. Brigham and Women's Hospital has not identified a single case that says that it does. We identified the Grimes case.
Identified a case that says that it doesn't?
I did, Your Honor. I identified the case of
Maryland, right? Not from Massachusetts.
No, it was the case in Maryland, and the case in Maryland drew a clear distinction between human subject research and medical care, therapeutic medical care, and that human subject research.
But the facts of that are very, very different than the facts here. The Maryland case, not to belabor that point, but are entirely different. There's no therapeutic purpose in the Maryland case at all. Am I correct about that?
You may be, Your Honor. I mean, I agree that there are differences, but nevertheless, the principle remains that in human subject research, there are causes of action that apply: negligence and breach of contract. And in therapeutic medicine, there are causes of action that apply: medical malpractice. And they drew a clear distinction. And they said that medical malpractice does not apply in human subject research. And there are other reasons. I mean, the purpose of the medical malpractice statute is to respond to the crisis in medical insurance. And there's absolutely no evidence in the record, direct or circumstantial, that medical malpractice insurance would provide coverage for a DBS claim, a DBS for depression claim. The only evidence in the record regarding insurance is to health insurance. And the evidence is that health insurance did not provide coverage for Baca's DBS because it was experimental. So absent that evidence that medical malpractice insurance would respond, I don't see how the hospital can argue that the statute is implicated. And the third.
Sorry, Mr. Rafelson, your time is beyond expired, but I will let you briefly finish this, and then I have this point. Briefly, please, and then I have two more questions.
Yes, absolutely. The third point that I want to make, and I think this is an important point, is that only a contract claim permits Ms. Baca to enforce the hospital's promise to pay for her DBS. She can't sue a clinician under a malpractice theory to recover the future costs of her deep brain stimulation. She just can't do it.
Okay, my next question for you is regarding the intentional infliction of emotional distress. What evidence is there in the record that the hospital intended to cause your client emotional distress?
Well, there is evidence of Dr. Erb. I think that the intentional infliction of emotional distress claim, that standard is that the hospital
requires intent, and it requires that the conduct be extreme and outrageous.
That's right. And so the extreme and outrageous conduct, that knowing that Ms. Baca was dependent upon DBS, and that any interruption of her DBS stimulation put her life at risk. They repeatedly with the battery exchange, with the November 2015 letter agreement telling her that she had to sign it, with refusing to transfer her care because it did not have a qualified programmer. All those things put her health and safety at risk, and they did it deliberately. And the jury could infer that from the facts that they did it deliberately to avoid or evade its contractual commitments that it made to her. By the time in November 2015, the hospital had abandoned the psychosurgery program, and the only liability that remained was Ms. VACCA. And they put an administrator charged with the responsibility of controlling the costs of the Department of Psychiatry on to respond to her request for a written document memorializing the contractual commitments. And
No,
one of the things
we're aware of the Fernandez letter and the back and forth. Okay.
Yes, all of those facts, Your Honor, I submit would allow a jury to conclude, a reasonable jury to conclude the conduct was extreme and outrageous under the circumstances.
I'm sorry, Mr. Chair, may I ask one more question?
Of course, Justice Englander.
So as to the issue of the Fernandez proposed agreement, how was your client harmed by that? Assume that I would agree with you that there could be a breach of the duty of good faith and fair dealing in that context. Where's the harm?
Yes. Well, I don't believe that the Rockland Trust case requires harm to establish or to prove the breach. So, but once there's a breach, the harm is the future cost of the care. And also, I would say that if you don't accept that, then the harm is that she had to, because they threatened her and tried to coerce her into giving up her contractual rights, she had to hire a lawyer and pursue her remedies, and that's the harm.
So when you say the future cost of the care, has she incurred, my understanding is she's still being treated at Brigham and Women's, yes?
No, she is not, Your Honor. She hasn't treated with Brigham and Women's for almost 4 years. She's periodically gone to New Hampshire, which is the closest place that she can get this kind of care. This is a very specialized field. There are very few people in the world that do it, mostly well outside of this region. And so no, she has not been treating with Brigham and Women's Hospital. She didn't treat with Brigham and Women's Hospital since she sued on the contract to enforce her rights, with the one exception of the 2016 battery exchange surgery that she was compelled to go to. It was under duress because she moved for an injunction requiring the hospital to pay for that surgery at Brigham at Beth Israel. The court declined to order the injunction, and because if she lost DBS, she might lose her life. She mitigated her damages, reserved all her rights, and went forward in 2016, but hasn't since gone back to Brigham.
I'm going to stop you there, counsel. Let me just check. Either justice have any further questions? Thank you for your argument. We will now hear from the counsel for the appellate.
Thank you, Your Honor. Good morning to the members of the panel, the clerk, Mr. Rafelson, and my colleague, Ms. Cobbs, who's also attending by Zoom. Appreciating the court's comment that the court has obviously read the briefs and the exhibits. I would start with this. The case before the court really is an example of strategic litigation. I admire it. It's creative. It's good advocacy on Mr. Rafelson's part.
Counsel, I'm going to interrupt you right there. For at least for me, I don't know about for the others. That is not a particularly powerful argument. There was a contract here under which your client clearly incurred some obligations. They incurred an obligation to make payments, and he had a right to make a contract claim. So I think we should, at least for me, unless my brother and sister feel differently, I think we should talk about the contract claim.
Thank you, Your Honor, and I appreciate the court's comments. I do maintain my position as set out in the brief, but I will move forward with that in mind. However, appreciating the court's comments, I would still say it's appropriate to consider my point in that Mr. Rafelson's argument includes the claim that, but for the way the complaint has been structured by Mr. Rafelson, his client has no remedy. That's one of his arguments to this court on why the claim, or rather the summary judgment, should be reversed. And I would suggest that that's not true. The only reason that argument is being made is strategic. I would suggest before the court that if Ms. VACCA, through her expert, who has a very detailed analysis of his criticisms of failures to provide care in accordance with whatever standards he sets out, I'd suggest that they're medical standards. If she wished to pursue a malpractice claim, Your Honor, I would suggest that I would not be able to stand before this court and say, there's no standards that apply to what was done to Ms. VACCA. I think I'd be laughed out of court. So the strategy behind it, I do think, is for the court to consider, because I'd suggest it's just not true that his client doesn't have a malpractice remedy. I don't think she'd prevail, but I think she does have that remedy. The reason she's not pursuing.
Say to your brother's response just a few moments ago, when I asked him the question about malpractice, that these are decisions being made by administrators, and that because they're being made by administrators, they're not really medical decisions, or they're not decisions that are subject to the malpractice laws. What do you say to that?
Well, I think we have to look at first what decisions we're talking about. For example, the decision on a rechargeable battery versus a standard battery. That has to be analyzed in the context in which that decision was made, and in which the issue was discussed with the patient. Dr. Cosgrove's testimony that's before the court is clear. Not only did he discuss rechargeable batteries with the patient, he also discussed what he really felt should be done in his medical judgment, which is ablation surgery, which the plaintiff wants no part of. She was quite critical in her briefs and in her expert affidavit about that medical judgment of Dr. Cosgrove. So, for example, starting with just the battery, that is a medical judgment decision. And Your Honor, for example, I would just point to the fact that at the time of the 2015 surgery, certainly 12, 13, and 14, and I believe even in 2016, standard batteries were and are used. So there is judgment that goes into it. The judgment comes from the fact that—
is there a line that has to be drawn in the cases between what is an allegation that has to do with hospital administration, if you will, and decisions that are medical care? Are there cases that tell us how to draw that line?
Well, the legislature, in its enactment of the statutes governing the law of medical malpractice, and the court in the case of Salem Orthopedics, has indicated that when it comes to a doctor's treatment decisions, absent an express comment to reach a particular medical outcome, there is no breach of contract claim. And in this case, all of the claims, setting aside the Fernandez letter, which I'm not ignoring, all of the claims relating to the alleged conduct of the quote unquote hospital are really decisions being made by medical providers, including the battery exchange, including whether or not Dr. Sullivan, who was a psychiatrist, was qualified to adjust the settings on the DBS device. All of these are medical judgment claims, Your Honor. And with respect to the DBS device itself, I'm confident the court appreciates this from the briefs and the information already. But while it is true that deep brain stimulation for treatment-resistant depression is not FDA approved, the idea that this is experimental is not founded in reality. Deep brain stimulation as a treatment for other disorders has been going on for decades, literally decades. Placing the electrodes in the brain, having the neurostimulator, having the battery, the wires, all of that is not experimental, novel, new, or beyond what is done all the time in medical care.
Go ahead, Eric.
Does it fit within the category of human subject research?
No, it does not, Your Honor. There's nothing before the court, and I'll get to the website. I appreciate the language in the website. I didn't design it. I wouldn't have designed it. The reality is research, which is heavily regulated by the federal government, involves research. There was no controlled study being done. There were no patients who were receiving placebo treatment versus patients who were actually being treated. There was no control group. It was not research. I would suggest that the information before the court, starting with Dr. Erb's letter to Julia Sinclair, the vice president Brigham and Women's Hospital demonstrates what this really was. It was a last-ditch effort by a clinician who had cared for this patient for some 17 years to try to help her because
I understand that argument. So, but let's assume hypothetically that there is an issue of fact as to whether or not this constitutes human subject research, hypothetically. If that's the case, do you have any authority for the proposition that the medical malpractice statute applies to human subject research?
If this were human subject research, Your Honor, I don't think it could. I don't think the premise could be stretched beyond it being research in conjunction with actual treatment. And on those facts, the medical malpractice regime would govern the liability of any providers. For example, Dr. Erb speaking with the patient and providing therapy after the placement of the device, Dr. Cosgrove in the surgery, in the consent process about the risks of infection and how we made the incision, all of that is being done for treatment.
What's the best case for the proposition you just made?
Well, I believe that in the Maryland case that Mr. Rafelson cites, there was no treatment component whatsoever. I believe that, and it's really a 93A case. I don't recall if Dark versus Eisner involved that issue, but I believe that that was treatment related. It was not research in the sense of putting together a controlled group and coming up with a hypothesis and testing the hypothesis. So all of the conduct by Dr. Cosgrove, by Dr. Tierney, by Dr. Sullivan, and by Dr. Erb were all in the context of medical treatment. And as far as the facts of that go, it's all recorded in standard medical records kept by the hospital in the ordinary course of business.
So help me with it. I'm sorry, did you have another question, Judge Neyman?
No, I yield.
Help me with this, because I'm really, this is fascinating, but complicated, right? There is at least to this judge, there's a contract here. There's an obligation to, for free, provide her with some sort of treatment. Does that contract include an implied agreement to provide that treatment in appropriate medical standards?
I don't think that really is, Your Honor, I don't think that is consistent with the legislature's scheme governing medical liability. And with respect to the court's, Your Honor's statement that Your Honor's view, there is a contract, taking that and moving forward from that, if there were a contract, and again, I don't want to die on the hill, but I'm going to keep.
I understand. Just accept it as a hypothetical, counsel, and let's try to figure out what the terms of this agreement are and how they play out in terms of whether they're malpractice or something else.
And that's what it comes down to, Your Honor. If there were a contract, it's limited. It is not. There was absolutely no discussion between the parties to this contract about the type of battery that was going to be provided. There was no discussion between the parties or any. In fact, Ms. Vaca even says she wasn't even aware that Dr. Erb was petitioning the hospital for her benefit.
They weren't going to have the janitor adjust the electrodes to determine where it was appropriate for her. They're going to have someone apparently who's qualified to do that. Isn't that implicit in an agreement that says we're going to implant electrodes and then going forward we're going to adjust them as appropriate?
It's not. It doesn't need to be implicit in the agreement, Your Honor, because it's a matter of the physician's duty under tort law. No doctor could have. I do not believe that even if they got Ms. Vaca to sign a written agreement saying the janitor is going to adjust the settings, I don't think that would hold up in a malpractice case. The physician's duty to meet those standards arises from the physician's duty under tort law. So the theoretical deconstruction of a contract to see if it would include those kinds of terms, I'd suggest is not necessary. It's a theoretical exercise. All of these physicians had an obligation to the patient by virtue of their duty as physicians.
Unless someone else has a question, I'm going to jump in again. Can we turn to the episode with the November proposed agreement?
Yes, Your Honor.
That's not providing medical care, right? That's contractual.
Well, the letter is certainly not providing medical care. The
Okay.
letter,
And under the law, you can be found to be in breach of your covenant of good faith and fair dealing if you appear to be clawing back something that you previously agreed to under circumstances where you put undue pressure on the other side. Why aren't the facts adduced at summary judgment sufficient to show that?
because the facts adduced in summary judgment demonstrate that this letter was not put together by the administration of the hospital, having thought through, we want to get rid of this patient. The letter was put together under the facts before the court that are not disputed, purely in response to a request by the patient to have something put in writing. There was then an effort undertaken to put something together in writing. Accepting the court, I'll accept for purposes of the argument that Your Honor is saying that the letter did in fact have terms that were different from those negotiated. Again, I don't think there was any negotiation. I don't think any terms were reached. But if we accept that,
well, the agreement, as I understand it, said it could be terminated at will by either side, right?
That the letter absolutely does say that. I'm not suggesting that that would have ever been enforceable, and nor do I believe that, oh, excuse me, Your Honor, strike that if I may, nor would I suggest that the facts before the court indicate that that was something, anything more than boilerplate put in purely because of the effort by the hospital, now including the general counsel's office, to put something together in a legal document.
Well, that letter was never agreed to.
Sorry? No, Your Honor. Agreed to. And I would also say that even though the letter was not agreed to, at no point did anybody refuse Ms. VACCA care. In fact, as the letter is being put in the mail, and I know plaintiff may suggest that this timing is not fortuitous, I would suggest it is. As the letter is being put in the mail, Ms. VACCA is meeting with Dr. Cosgrove, who's telling her, come back next year, maybe we can look at a rechargeable battery. Incidentally, she didn't even want a rechargeable battery by the time of the surgery. So there was clearly no effort to pull back care at all from her, despite the language that was included in that in some of those boiler paragraphs in the letter. The letter is
well, you
really
call it the boilerplate, but my understanding is that Fernandez later stated, if you won't sign that, then we're not going to go forward with the treatment. No?
No, Your Honor, I don't believe that's true. I believe that in Mr. Rafelson's questioning, he recited portions of the letter. Doesn't this mean that? Doesn't this mean that? But Mr. Fernandez never on his own said, hey, if she didn't sign the letter, she's done. Nobody ever said that. In fact, quite the opposite, Your Honor. She came back in 2016. Granted, she had gone to court to look for a preliminary injunction because she didn't think the hospital had qualified people. Again, standard of care claim in our view. And the hospital performed the surgery, again, without cost. You know, even on the battery, it is sort of interesting because the rechargeable battery actually would have saved the hospital money, because to do a standard battery is going to mean another surgery, which in the long run costs money. And there are medical reasons for one versus the other, which I believe the briefs discuss. So to go back to, I think, the court's question on the letter, I would suggest that on the facts before the court, that is nothing more than boilerplate. There was never any threat to cut off Ms. VACCA from care. And so it's quite theoretical to question whether or not this letter is a breach of a contract that, again, we suggest wasn't reached. The overarching claims by the plaintiff in almost every single.
Let me stop you right there. Sorry, your time has expired, but I'll let you finish this thought, and then I have one additional question for you, and perhaps the other justices do as well. Go ahead.
I believe what I was saying is that there's no evidence to indicate that there was ever any effort by the hospital to get out from underneath their ongoing care of Ms. VACCA right up through 2016. And in fact, the hospital has specifically said they are ready, willing, and able to meet their obligations to the patient.
So let me ask you one final question. Justice Englander expressed some doubt or some concern as to the argument as to whether or not there was a contract formed here, an oral agreement. I understand your argument about medical malpractice preemption, so for purposes of this question, set that aside. Why is it that there was no oral contract agreement formed, keeping in mind that in the light most favorable to the plaintiff, the hospital promised to provide this treatment and aftercare at no cost, and as consideration, therefore, they would be able to promote this new procedure and new practice as part of their skill set, if you will. Why does that not constitute an oral agreement?
There was no explicit discussion between the parties about any contractual terms, including promotion. My recollection of the evidence before the court is that Ms. Vaca was not even aware of the petitioning activity. And while it is true that the website featured her case on the website, that really comes from what the hospital does in just about any case that involves an academic teaching hospital whose function is research. To go to the court's question, my position that I maintain is that there was no contract, in part because there was no consideration on part of Ms. Vaca, and I understand that there can be either detriment to one side or benefit to the other. That wasn't a material term, it wasn't a bargain for term. And none of the allegations underlying 95% of plaintiffs' position on what breached the contract were in any way terms of a contract, but rather the subject of disputing expert affidavits between Dr. Schlapfer and the defense experts.
Okay. Justice Hand?
Also,
Justice Englander?
Sorry, I got one more. On page 40 of, this goes back to a question I asked you a few moments ago. On page 40 of the plaintiff's brief, they quote Fernandez as saying, "I told Vaca in substance that BWH has the expertise to provide the care and will provide it, but only under the terms of the November 16, 2015 letter agreement."
Yes, Your Honor, and I believe that that quote comes from a question posed by Mr. Rafelson. Those are Mr. Rafelson's words, to which Mr. Fernandez, in the colloquy of a rather lengthy discussion about the letter, answered yes. However, also on the pages of that deposition before the court, Mr. Fernandez's testimony that this was an effort to accommodate her request, but for her request, this never would have been drafted. Instead, she would have just continued to see Dr. Erb. The following year, she would have had a battery rechange, likely with a rechargeable battery, because the medical standards were changing by that time. So yes.
That quote is actually, that's counsel's language, which which Fernandez adopted.
Yes, Your Honor, I believe that's correct. And if the court can give me a moment, I should be able to.
No, that's all right. We can check that. Thank you.
I think I've got it flagged, but.
It's okay, Mr. Sullivan, we're all set. We appreciate it. We will find it in the record. And I'd like to thank both counsel for their excellent briefing and their very helpful arguments today. So
Thank you, Your Honor.
I do, Your Honor. And I mentioned that in our reply brief. At the time that we filed our opening brief, the King decision was not yet on appeal to the SJC. And in our reply brief, we mentioned, staying this matter pending the outcome of the King appeal.
Okay, thank you.
And so in our reply brief, we did request that a stay be issued pending the appeal because we do believe that the King matter will be dispositive of this appeal. However, I'm happy to go into my argument should the panel wish that I do so.
Absolutely, please do.
Here, the single justice committed a reversible error of law in determining that the periodic rent requirement under GL General Laws Chapter 239 5E is per se inapplicable in a post-foreclosure appeal. Under Massachusetts General Laws Chapter 239, under either Section 5 or 6, an appeal bond is required for an appeal of a judgment of possession against a defendant. Section 6 applies in the post-foreclosure setting, which is where our case arises under today. B&Y Mellon was the foreclosing mortgagee, and Ms. Dundon was the former mortgagor. Section 6 lays out the damages to be included in the appeal bond, and specifically includes a reasonable amount as rent of the land from the day of the foreclosure until possession of the land is obtained. So despite the fact that Section 6 falls within a post-foreclosure setting and that there is no lease between the parties, the legislature has still used the term rent when determining the amount of damages under Section 6. Now, it's important to note that Section 6 does not include a waiver provision for indigency or non-frivolous appeals. However, under Section 5E, which is where the issue arises in this appeal, it does provide for a waiver, although 5E doesn't specifically apply to post-foreclosure matters. However, this court has determined in the Camillo case that the procedures under Section 5E will apply to Section 6 matters. So the court may waive the bond provision under Section 5 or 6 if the appellant is found to be indigent and has at least one non-frivolous defense on appeal. However, even where the bond is waived under Section 5E, the statute still requires the appealing defendant to make monthly payments pending the appeal. The specific language of Section 5E says the court shall require. It doesn't say may require. Any person for whom the bond or security provided for in subsection C has been waived to pay in installments as the same becomes due, pending appeal, all or any portion of any rent, which shall become due after the date of waiver. Thus, Section 5 plainly...
Counsel, what do you do with the language which shall become due? I mean...
Well, Your Honor...
That implies, doesn't it, that there was a rent that was actually set?
Well, in this context, Your Honor, rent, as we just looked at in Section 6, has been used interchangeably to mean use and occupancy. In fact, in a summary process matter, Your Honor, under Chapter 186, Section 3, the legislature has used the word rent for tenants at sufferance, which is what a form mortgagor is after a foreclosure sale.
Right, but I think, counsel, I understand that argument, which is very well made in your brief, but I'm asking sort of a question that's even, that I think goes back farther and asks, what do we do with the plain language of the statute, which says which shall become due? That suggests, it seems to me, that there is something which has been set in advance, which shall become due. And you're asking, yes, Your Honor, but to do what with that language?
I'm asking you to apply it in context with Section 186, Section 3, which says that in a post-foreclosure matter, a tenant at sufferance must pay rent or use and occupancy. So that number is set. That is the amount to become due. And that's determined by the fair rental value from the date of foreclosure to the time of possession by the plaintiff.
It says in Chapter 186, Section 3, that's all referring to a tenant who holds over, and that the entire purpose of that was in a context where before we'd sort of avoided privity rules. Because there was no privity, a tenant in a holdover situation owed nothing. And that was the purpose of 186, Section 3. What do you say to that? And in that context, there would have been a rent set. It was just a rent that was owed to someone else.
Well, you're on to that. I mean, as the SJC, outlined in King during oral argument, they mentioned, what is a form mortgagor? What is that person called? What are they deemed to be? And they're deemed to be a tenant at sufferance. So that's exactly what Section 6 says, tenants at sufferance in possession of land. I mean, that's how I would apply that. That's what a form mortgagor is. And in that context, even the court in Commonwealth has said rent or use and occupancy are interchangeable. I believe that would provide a basis. And that's the basis in which foreclosing mortgagees obtain use and occupancy judgments in summary process matters now. So I do believe.
Mr. Polinsky, in Davis versus Comerford and the Ajardi case, did either of those cases involve an existing lease or an existing tenancy?
Yes, I believe both were related to lease matters. They were not post-foreclosure matters. But I believe the language can still be analyzed by what the court has mentioned in those cases where it doesn't use the word rent. Even though they're tenancy matters, the court should have been using the word rent. They don't, because rent and use and occupancy are used interchangeably in this context. But more specifically, when you look at statute construction, And although I can't see you, it goes back to one of the Honor's questions about, well, what do we do with the language of any rent shall become due?
That was Judge
Well,
Englander. I apologize. I should have identified. I forgot that you're on the phone.
I'm sorry, Your Honor. Yeah, I wasn't allowed to use the Zoom.
No, that's my fault.
And so when we look, we can't take a narrow construction. I mean, again, the waiver provision doesn't apply to Section 6. It only applies to Section 5. So if we're going to look at this narrowly, then there is no waiver provision under Section 6. And so you can't look at the two sentences and state that, well, you know, the first sentence on the waiver applies, but the non-payment of the rent portion doesn't apply, even in a post-foreclosure setting where we use the term rent to become due. It has to be given its most logical and rational meaning, which is exactly the whole purpose behind the statute and the addition of that sentence, which was to defray some of the financial burden for landlords in eviction matters. And that's what this does. It would make no sense that there would be a benefit to a tenant, but not in a benefit to a landlord in a tenancy relationship, but not a benefit to a landlord in a post-foreclosure situation where the economics or the equalities just aren't the same. In a post-foreclosure matter, the mortgage company has likely foreclosed on an individual that has not provided any mortgage payments for years. In this case, it's been, I believe, since 2009. So there hasn't been any payment towards carrying costs, towards mortgage payments, towards taxes in that period of time. And to allow this individual who hasn't paid anything for over 10 years to continue to litigate an appeal with no payment of anything because the language is being illogically analyzed or rationalized doesn't make any sense. And I think if you look back at the oral argument of the SJC and the King matter, they seem to come to the conclusion, although there's no written decision, and I'm reading into their questions and statements, but that something's due. What is it and how do we determine what that is? But they didn't seem to suggest that no rent would be due or nothing would be due. It was more how much and how do we determine it. And I think that's the way that this application of the two sections should be applied. There shouldn't be a selective application with respect to the first sentence and not the second in Section 6. I think that they have to be read in conjunction. And the most logical reading would be if this is a Section 6 case and 5E applies because there's an indigent appellant and they have a non-frivolous appeal, then the amount to be determined by the payment amount would be use and occupancy. What is the fair rental value of that property? Or, as Section 6 guides us, any other costs of foreclosure through the present. I think that's the most logical reading of this statutory construction.
Mr. Polanski, this is Judge Neyman. I have one final question for you. My reading of the record before the single justice is that he made a determination that indigency was not disputed. And I believe the non-frivolous claim on appeal that he referenced was the legal claim concerning the were there any other non-frivolous claims alleged by the defendant in the housing court?
Well, it's tough for me to argue that. I mean, my position would be that they are frivolous, but to the extent that they're identified, there were other defenses identified. Whether they're non-frivolous, I think, is something that the single justice didn't get into. The only issue that the single justice really decided was this obsolete mortgage statute reference, which at the time had not been decided.
Right, and now has been decided.
Right. So he didn't address any other issues as being non-frivolous.
Could I piggyback onto that question? This is Catherine Hand. And ask, my understanding was that the single justice indicated that there was a statement by the trial judge from the summary judgment motion that, from the bond hearing, that there had not been evidence offered, at least timely, to support any of the other defenses. Can you give me an idea as to how to interpret that?
Yeah, so in the motion of summary judgment that we presented and filed, there was an opposition. It was very bare bones. There wasn't much presented, if anything. There was a motion to reconsider filed that alleged a number of other issues. I believe standing was one. The obsolete mortgage statute was one. And I regret that I don't have all of the different defenses raised. But even at that time, there were no affidavits or other admissible evidence presented that would have allowed her to have pursued those, assuming that she had properly or timely presented them in opposition to the summary judgment motion and not in the motion to reconsider. And so she didn't address those issues.
Is she required to address them, or is she merely required to raise them?
When you say she, Your Honor, are you referring to the defendant or the judge?
The defendant.
Defendant is required to raise any issues of material disputed fact that would prevent the entry of summary judgment.
But my understanding for purposes of the bond hearing and seeking to waive the bond is that they're alleged non-frivolous claims. I don't know that they need to go into great depth in addressing them and present them by affidavits. I understand it's summary judgment perhaps, but for the purposes of waiver of bond, I don't know that there's such a requirement, but perhaps you can correct me.
No, Your Honor, and I interpreted your question to mean at the summary judgment hearing. I apologize.
In the motion for relief from the appeal, so for waiver of the appeal bond, what were the non-frivolous defenses that were asserted? Obsolete mortgage was 2 words, right?
Yes. I apologize. I don't have a list of all of the defenses raised. I know the only one that was really discussed was the obsolete mortgage.
And the judge denied the waiver, right? Refused to waive the bond.
Are you referring to in the lower court, not single justice?
Yes.
Yes.
Okay.
Yes.
So it goes to the single justice on a decision by the lower court that does not find any non-frivolous defenses. And the only one that is identified by Judge Rubin is the obsolete mortgage. But you are not appealing from that part of his decision, am I right?
Yes, that is correct. At the time, I believe that the obsolete mortgage statute had not been resolved. And so we did not appeal from that portion of the order.
Okay, I see your time has expired. Unless there are further questions from either justice. And seeing none, thank you for your argument, Mr. Polanski. We will now hear from Ms. Dundon.
Thank you, Your Honors.
Good afternoon, Your Honors. Deirdre Dundon, appellee. May it please the court. I would like to first address the appellant didn't address the fact that one of their arguments is that my appeal was untimely. So I would like to address that. The appeal from the waiver of the bond was made within 6 days of receiving the housing court's decision. I received it on May 28th of 2019. And I filed my appeal on June 3rd because June 2nd was a Sunday. So that was within the 6 days. And I just wanted to address that it was in fact timely.
As I understand Mr. Polanski's argument, or the bank's argument, I should say, they state that may be so, but there's nothing in the record before us demonstrating that. I'm not suggesting that anyone here is doubting you, but can you point to us any place in the record where there is an indication as to the date on which you received that notice?
Well, I'm not sure how I could prove that. Either way, I believe it's within 10 days of the court's decision or within 6 days of receiving the decision. So either way, it would have been within 10 days of the hearing. or within 6 days of receiving that. I do know that May 27th was Memorial Day, so there was no mail that day. So I received it on the 28th, which was a Tuesday.
Okay.
And as I
Ms.
said,
Dunn-
I'm not sure how I would provide proof of when I received my mail.
We understand your argument. I think, well, I'd like to, before you get to the substance of your argument, I'd like to ask you the same question I asked Mr. Polanski, which is, do you agree that the SJC's decision in the pending case before it that I cited earlier, the other Bank of Mellon case, is likely to dictate the outcome in this case here?
Yes, I do believe so. Yes. The other thing I would like to say is I do believe that Single Justice Rubin was correct in his interpretation of the statute, where there's no tenancy relationship here and the bond is waived. There is no rent that becomes due. So there should not be any, the court should not require any other payments pending appeal. So I do believe that his interpretation was correct on that. I would also like to address one more issue, if I may, regarding the appellant's reply brief.
Please.
The Rules of Appellate Procedure 16C states that no new issue should be raised in the reply brief. And on the very first page in the footnote, the plaintiff in this case raises some concerns that there was a ghostwriter or unlicensed lobby in regard to my brief. That's never been raised before. They claim that there's been a concern since this all started in housing court. However, it's never been raised once. And they put it in the reply brief, and of course, I'm not able to respond to that. So I just wanted to be known for the record that this is the first time this has ever been raised, this concern of theirs.
Okay. We note your concern and your argument. Thank you.
Yes. I'm not really sure if you have any questions for me.
Ms. Dundon, this is Catherine Hand. Could I ask this question? Was the judge in the housing court correct that you did not raise any of the defenses in a timely way?
I believe I did. I raised in the broader sense concerns that the plaintiff did not properly hold title to the property and that the foreclosure wasn't done properly. But in my motion for reconsideration is where I listed the non-frivolous defenses that I had.
Thank you.
Yes. I really don't have any other argument.
Okay, I have no further questions for you. Let me check with the other justices.
I'm all set, thanks.
No, thank you.
Okay, seeing no further questions. Ms. Dundon, I thank you for your argument. Mr. Polanski, thank you for your argument as well as your very helpful briefs. And the case is submitted. Thank you both.
Thank you.
All right, we are live.
Good afternoon. Calling the final case on our list today, 2019 P1382, Skadoodle versus Melanson. I will remind the parties that this case is being live streamed and recorded. And otherwise, normal appeals court rules are in effect. Each side has 15 minutes. There is no rebuttal. And this case is also paired with the matter we just heard, 19 P1116, Bank of Mellon versus Dundon. With that in mind, we will hear first from counsel for the appellant. I believe that's Attorney Loeb.
Yes, good afternoon, Your Honors. Thank you. May it please the court, Jeffrey Loeb on behalf of Jason Skaduto. I heard watched on YouTube. It's all different now. The prior argument, as opposed to having sat in the courtroom. So I heard Justice
So
Neyman.
you're going to answer my question first.
Yes,
right?
I thought I would, or I thought I would start there. My view is that this case, for the most part, is going to be bound by what the SJC decides in the Alton King matter. And my intention, in light of that, and in light of the fact that you just heard the Dundon case, was to not address the issues specifically addressed in the Alton King matter, unless the court had questions beyond those that you've already asked Attorney Polanski, or follow-up questions in terms of what you've asked Attorney Polanski, because I think you've already covered the specific issues regarding the interplay of sections 5 and 6. Happy to answer those questions. My focus...
I actually do have one question. I'm sorry to interrupt.
That's okay.
How should we look at, and I hope I'm pronouncing this correctly, the Ajardi case? And should we look at it? Is it controlling? Does it have some helpful language for us? How should we interpret that case vis-a-vis the, let's call it the section 5-6 interrelationship?
I think that what Ajardi can help you with, and it's really, I think, Ajardi and Davis v. Comerford together can help the court with, is the whole concept, some of which that bothered Justice Englander, on the question of what's supposed to be paid, how is it supposed to be paid, and what are we calling it? And watching the SJC argument in the Alton King matter, that's, I think, where Ajardi came down, and the concept that the legislature use the term rent in many cases where it should have been calling it use and occupancy. That, for example, in section 6, that the term rent is used in a post-foreclosure situation, in describing what would be paid in a post-foreclosure situation. That's never going to happen. That technically, that's not rent that's paid in that situation. In fact, that was one of the questions that Justice Gantz asked during the Alton King argument. What do we call that? To the extent to which anything is going to be paid, it's clearly by law use and occupancy payments, notwithstanding the word rent in section 6, although I think in some spots, instead of just rent, it's as rent. And so maybe that's the broader term. But I think from Ajardi, I think that's what the takeaway is, and that we have to look, as we're interpreting these statutes, a little bit broader.
But the legislature chose the word rent.
It did, but if you're analyzing the statute, when you look at section 6, we all know it's not rent. That it can't, so that if you're reading that, you have to give some reading to it. Otherwise, that phrase is absolutely meaningless. And from a statutory construction standpoint, we have to give it meaning.
The language, I'm sorry, counsel, it's hard.
Yep.
And I'm not nearly as polite as my co-panelists. I just interrupt. But the language in section 6 says as rent, which suggests that it's maybe something other than rent. The language in section 5 talks about when it becomes due, which suggests that it exists in advance. Now, I'm not telling you that I think that's necessarily dispositive, but aren't I right that there's some difference in the way the language is used?
Yes, but I don't agree with what you've said, Your Honor, that section 5 necessitates that it had to have been a pre-existing agreement. That the items due, the court could order it. In the same thing, whether it's a Comerford situation or what we have here, where you have the court ordering a payment, that because otherwise you would make section 6 a nullity. And if you're going to look at something like the only case that I can find that a panel of this court dealt with in this area, which was the Novastar case, and they said you can't pick and
make section 6 a nullity. Be careful about overstating it. Remember, section 6 doesn't address waiver of the bond at all.
Well, right.
The critical language that you want to tie into is in section 5E. It would not render section 6 a nullity. You could say as rent is part of how you determine what the amount of the bond is.
You're right. Well, I'm saying that you have to read everything together, Although there's an argument, our last argument is that actually no, when you look at section 5, and I've said I really don't intend to go there right now unless the court wants me to. If you look at section 5, it simply says as set forth in this section. So you could argue that the waiver provision doesn't apply at all in a post foreclosure situation. That's the last argument we made in our brief.
Are you arguing that?
It is in our brief, Your Honor. I'm not planning on pressing that today. It is, if you read this, if you read it, and I'm not waiving the argument.
That argument below? Your brother says they didn't argue that below.
I don't recall
hey, you're not entitled to a waiver at all.
I don't recall what we argued, whether we made that specific argument either with the housing court or with Judge Villano. I don't recall whether we said that or not, one way or the other. The focus where I want to come with this afternoon's argument is on the concept of whether or not the Melansons have any non-frivolous arguments in this case. It's the first argument we assert. Frivolous in this context, meaning not a prayer of a chance. They've asserted two arguments in going through their papers. One relates to the fact that Judge Del Puerto excluded their expert opinion. And the second, they say, relates to whether or not the notice that was given was proper. With respect to the first of their arguments, the exclusion of the expert, the problem with their argument and where it ultimately fails and why it doesn't have a prayer of a chance is that when Judge Del Puerto excluded the expert opinion, they did not then make an offer of proof to put on the record that which they would have gotten from their expert.
There was no expert report?
No, there's no expert report. And there wouldn't have been from an admission standpoint. That was not in part of the trial record. So to try and fix that, and if you look, it's pleading number 73 on page 11 of the appendix, you will see that after the trial, they then file a motion, a post-trial motion, to belatedly file an offer of proof. And Judge Del Puerto properly denied that motion as too late. So from a timing standpoint, first of all, we know the admission of an expert that's a discretionary call by a trial judge. Then for this court to evaluate whether or not an expert should or should not have been admitted, we need to know what's the expert going to say. That should have been in the record, should have been in the trial record. It wasn't there.
Actually, it's a little bit the other way around. Do we have the trial transcript?
You don't have the trial transcript. What you do have, though, Your Honor, is you have the docket showing that's why I'm saying no, it's pleading 73. You have the docket showing their attempt to put that into evidence afterwards.
Okay, but so counsel, you're appealing from a decision by the judge below in the exercise of her, I can't remember if it's a her or him, but
it was a her. The single justice was Justice Villano.
Well, no, not from Villano, but it goes back before Judge Villano, a decision by the trial court to find that there were non-frivolous bases and to waive the appeal bond. And it seems to me that it's on you then to show us that these are in fact frivolous, that the judge abused her discretion. And how can we decide that when we don't have the trial transcript to figure out exactly what happened? Looking at a docket sheet and knowing that they tried to augment the record doesn't essentially tell us exactly what happened at trial.
Well, I think Your Honor can read into that, and it's fairly clear in terms of what their argument, when you look at their brief in terms of what they're claiming their non-frivolous arguments are, it's pretty clear from looking at the record and looking at the docket, there would be no reason to file such a motion had the proper filings been made. We unfortunately, when this appeal was filed, we didn't have the transcript. transcript didn't exist, and the transcript, in fact, hasn't been filed with the court yet. The briefs in the underlying appeal were due the first.
How did you argue this to Judge Vuno without the transcript? I assume
Based on the docket.
So you made
representations in terms
of her that these were actually frivolous.
Yes, and so that was based on the docket and based on what had happened, because the transcript didn't exist.
That's very helpful, counsel. Thank you.
The second argument that they make relates to a summary judgment motion that they filed that ties in, and there's a reference to it's the Thompson v. Chase case, which is also on appeal with the SJC. It happens to be under advisement right now. Their argument is, well, the court, that there was a non-frivolous basis, the court denied our motion for summary judgment, that should have been granted. What they miss is the fact that in the denial of that motion for summary judgment, what Judge Del Puerto said was that the issues underlying this motion have not been properly raised in the pleadings. That's how he began his denial. Then went on to say, in any event, had they been properly raised, they're issues of fact. So what we have, it's not a situation where Judge Del Puerto issued a decision that might be reversed depending on how the SJC rules in the Thompson case. It's that Judge Del Puerto, as the trial judge, as the gatekeeper, said, hey, wait a minute, you can't argue a summary judgment motion at the end of the case on an issue you've never raised before.
Well, can I just help me with something? Was there also a trial in this case as well as summary judgment pleadings?
Yes.
And didn't they raise this issue at trial?
They did not raise the Thompson issue. They did not raise the same issue on summary judgment at trial. Actually, they did not raise it. It was excluded based on Judge Del Puerto's summary judgment ruling. And he'd said to them, I told you at the summary judgment hearing, it's too late. You can't make this particular argument. That related to whether or not the language in the default notice tracked the language in the statute as opposed to the regulation, which was a separate argument. Their principal argument in this case, Your Honor, was that the payoff amount in the default letter, the cure amount rather, was the wrong number. And so
their argument as to why it is non-frivolous has to start with the court abused its discretion by refusing to hear this argument at trial. Is that right?
Yes.
Okay.
Yes.
Thank you.
You're welcome. And those are, I mean, I make those arguments because even if the SJC comes down against me in the Alton King matter, I suggest that there is still a reason why Judge Del Puerto's bond order should be in place and that my client is entitled to use and occupancy payments during the pendency of this appeal. And if there are no other questions, I'll rest on my brief. Thank you.
Seeing none, we thank you, Attorney Loeb. We will now hear from counsel for the appellee, Attorney Traft.
Good afternoon, Your Honors. May it please the court. Michael Traft on behalf of the appellees, the Melansons. I think the various courts that have dealt with this have had a difficult time identifying the identity of the individuals involved in this kind of situation in a post-foreclosure litigation. And I've used the terms that of the plaintiff being a purchaser of the post-foreclosure and the current individuals being occupants who are occupants of the unit or the house in this case. And the reason I say that is that it isn't a tendency. It has been a tendency. And that's the fundamental distinction in which makes the difference between these two statutes. When you're dealing with a post-foreclosure occupant, the legislature established a different form of bond, and that's what's included in Section 6. Section 5 establishes the kind of bond that's necessary for a person who is a tenant, has been a tenant. And the various cases that the defendant the plaintiff has talked about are all cases involving tenants at some point. And there may be a termination of a tenancy.
Tenant at sufferance.
Tenant at sufferance, right. Which is someone who had once been a tenant.
That's a tenant. I mean, as long as we're playing with labels.
Right. Well, I think the reason why I make that distinction is that a tenant at sufferance usually is someone who has already been a tenant at some point, and it is still remaining on the property. And
not necessarily, right?
Right, correct. So under those circumstances, that person would, that's the tenant in sufferance term. The difference here is there's a dispute between two people who both claim they are lawful owners. If the foreclosure was improperly conducted, then the purchaser, the plaintiff here, never had a valid purchase and is not a valid owner. And that's the nature of the dispute. So that's why there's a distinction. And I believe the legislature has recognized that distinction, which is why when they allow indigents to waive their bond, they require for a person who has been a tenant, who has no ownership interest, to make a periodic payment as long as they're continuing to occupy it during the appeal, as opposed to a person who is claiming a right of ownership, that there is no requirement if that person is indigent. And the fundamental problem
What do you do with the word rent in Section 6? I mean,
Well,
doesn't that?
Well, it says, first of all, it's talking about what is the composition of the bond. And secondly, it's talking about the composition of the bond, including an amount as rent, as if there were a rent, if this person were a tenant. That's the way I interpret that language. And that's why it's a distinction in not making the person a tenant. But in any event, once that's waived, then there is no requirement to, there's nothing, all the language in that section. Section 5E refers to providing for periodic payments for someone who's had the bond waived under 5C. So they're referring again.
Wasn't the waiver for your client under 5C? I mean, it
No,
wasn't under Section 6.
No, it's 5. Sorry, 5E is the waiver provision. And in Section 5E, it says, for people who've had their bond waived under 5C, these are people who are former tenants or tenants at sufferance or some other term. Those are the ones who have to make periodic payments. But
I follow that at all. Wow.
It doesn't. Yeah. There's that short phrase that says that refers back to individuals who have had a bond waived under 5C to pay periodic payments, and is really silent about Section 6. So I think those are some of the reasons why there's a distinction. The legislature certainly can make that distinction. Now, obviously, ultimately, the Supreme Judicial Court is going to decide this case under King, but it may or may not totally control the situation.
With that, Mr. Traft, the difficulty with that argument is that 6 doesn't provide for waiver, right? The post-foreclosure context, which is specifically referenced as a caveat in subsection 5C, all right, doesn't provide for a waiver. So the only way your client could get a waiver was by going under 5E rather than Section 6, right?
Correct. And
Right.
5E, why I refer back to Section 1, essentially says all of these provisions apply to everybody who is in the situation, such as the defendants in this case who were occupying a property when there's a claim they have no right to occupation.
Mr. Trapp, can I'm sorry, can you go back to your discussion about the pending SJC case and whether or not you believe it will dictate the outcome of this case?
Yes. One other question that may still be lingering in this case, if the SJC were to rule again, if the SJC rules in favor of us, obviously, I think it controls. If it rules against us and says there is a requirement to pay something, there may be a question of what is that something, and that would have to be determined. What happened here is the plaintiff testified, I think it's worth $3,000 for someone a month for someone to be there, and that's what the judge adopted. I think that if the SJC comes up with some different formula saying it's something that's a reasonable amount for this individual, if you're allowing a waiver of indigency, because a waiver of a bond because of indigency, then the amount that ought to be paid is something that the person could possibly afford. Otherwise, just a ruse to essentially have the case dismissed anyway.
Right, but that would be an issue of fact for the housing court judge to resolve in the first instance, right?
Yes, but what I'm trying to say is that if King rules totally against us and says that there has to be some payment, it doesn't necessarily mean that my clients lose and that the plaintiff prevails in this case.
As to the amount already ordered is what you're saying.
Right, correct. Right.
Did your client argue that below? Did they request some sort of reduction from the fair market value?
They didn't make a specific argument on that point, but the argument was rather that nothing applies and there's no requirement to pay anything.
Right. Well, now your point is that they should be able to get half a loaf. And my question is, did they argue for half a loaf? And I'm hearing not really.
No, yes, but I think that they would be entitled to it if the SJC essentially creates a new rule, because this would be a new interpretation of the statute to say that, all right, you're right, you don't have to pay a rent, but we have to decide what kind of rent you have to pay. And therefore, that would give them an opportunity to be able to litigate that issue and not lose entirely just because
at this point, there's no law on that either. I mean, Section 5 uses the word shall pay any rent, rent or part of. It's kind of awkward language.
Right.
But there's no law on whether, based on the ability to pay, it can be reduced from fair market value, at least at this point, right?
That's right. So if there is a new law interpreting that is what I'm relying on with respect to that. Now, in terms of the issue, whether there are frivolous issues or not, with respect to first to the exclusion of the witness, the issue was raised in a summary judgment. The judge raised the potential issues that would prevent it from being raised in the summary judgment position, but he denied the summary judgment and also said it would in effect be a factual issue anyway. Then he did consider that factual issue in the context of the case at the trial, and ultimately decided that the witness should not be allowed to testify. There was an opportunity to raise that in a post-judgment motion, and the judge was at least convinced enough to think that this was a non-frivolous issue.
At the summary judgment stage, was there an expert report or something provided to the court as to what the expert was expected to say?
Yes, there was an affidavit, I believe, from the expert as to what information she was going to present in the testimony. So there was something that the judge was aware of would have been presented by this, and the argument had been by the plaintiff at the summary judgment and at the trial that she shouldn't be allowed to testify as an expert anyway. And ultimately, that's what the judge agreed to at the trial. But without the difficulty is we're going through this argument is that none of that is before you in terms of or before the single justice. The single justice gets a report from a trial judge who thinks there are two non-frivolous issues. The single justice looks at it and sees there is no real basis to contest it. And the burden on this appeal to the single justice was by the plaintiff to show that the issues were non-frivolous before the single justice, and that they really didn't do. And so I think in that respect, you have to find that there's no basis to overturn the single justice on that ground. I'm not sure if the court has any further questions. I know you've gone over the parameters of this in the previous argument as well. Any further questions?
Nope, seeing none. The case is submitted. It was very well briefed by both parties, and thank you for your arguments. It's nice to see you both. And the case is submitted. And that will conclude our, let's see, May 13th, 2020 sitting. I'd like to thank the clerk's office in the appeals court for making this remote sitting possible. And we are now in recess. Thank you.